Yeah, sure. That'll be. I should wait and do it next year. Dad?
No, not a wise political move.
Oh, that stuff is hard. Here's a bunch. Personality.
You've already.
Oh, yeah.
All right, good evening, everyone. I have to show 6 o'clock, so we'll go ahead and call our regular session of December 19, 2017 to order at this time. First order of business we have is the opening prayer and pledges of allegiance to the flags of the United States and the state of Texas. Mayor Pro Tem Edwards will lead us in the opening prayer and the pledges this evening. If you please join me in standing.
Please bow your heads. Father God, grant us here in America and all over the world that we choose the highway, a way which men will live together as brothers, a way in which the nations of the world will beat their swords into plowshares and their spears into pruning hooks, a way in which every man will respect the dignity and worth of all human personality, a way in which every nation will allow justice to run down like waters and righteousness like a mighty stream, a way in which men will do justly, love mercifully, and walk humbly with God, a way in which men will be able to stand up and in the midst of their oppression and in the midst of darkness and anger and agony, that they will be able to stand there and love their enemies. Bless those persons that curse them and pray for those individuals that despitefully try to use them. And this, Father God, we ask that this way will bring about once more into a society which we will think of as a brotherhood of man. This will be that day when all people will join together in harmonious living in the city of Schertz as well as our nation. In Jesus' name we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Mr. Edwards. All right, next item we have on the agenda this evening are city events and announcements. And the first item we have are announcements of upcoming city events. Mr. Waite, appears you have the duty this evening, sir.
Yes, sir. Just a reminder, on Monday, December 25th, and again on Monday, January 1st, city offices will be closed in observance of the Christmas and New Year's holiday. And then next on our list of announcements, Saturday, January 6th, just another reminder, 10 a.m. at the pool in Pickerel Park is the Polar Bear Plunge with the YMCA. You can register online at ymca.org/polarbearplunge or in person at the Schertz Y. And I believe it costs $10, and that's a fundraising event. And then this just in off the wire, this Thursday at 8 a.m. At the Lower Seguin Bridge low water crossing across the Cibolo Creek, right where the Schertz-Cibolo city limits come together, we'll be opening the new low water crossing that replaced the one that failed. That's this Thursday morning at 8 a.m. And that's it.
Thank you, sir. Next item on the agenda this evening, announcements and recognitions by the city manager, Mr. Kessel.
Mayor and council, just want to make a quick update on the Schertz Parkway project. The final two pours are being pushed back a little bit because of the rain that we've had. It could affect the pouring conditions. They're going to try and pour the first section on Wednesday the 22nd and the last section on Friday the 24th. We're looking at possible rain on Friday, so that's the one that may not make it. We should have good conditions tomorrow, good sun. Before they pour, they'll be evaluating the sub-base to make sure there's been no adverse impact because of the rain. As you've probably seen, they've got the steel down and are basically waiting for the weather to clear. So We should still be on schedule for end of December to have that section reopened, at least to traffic, if not all of it, at least portions of it.
All right, thank you, sir. With the indulgence of the council, before we go into what may be some slightly lengthy workshops, I'd like to move to hearing of residents and give our folks that are here to visit with us an opportunity to come forward. So at this time, I have 3 people that have signed up. Miguel Gutierrez, if you'd like to join us, please, sir.
Mr. Mayor, council, city staff, thank you very much. I'd like to use the opportunity I've got tonight as a reminder that Christmas Eve on Sunday will mark the 2nd anniversary of my father's unsolved murder inside his home here in Schertz. What happened to my father was unimaginable, but what's also unimaginable is that here at 2 years after his murder, our family still doesn't have any answers. There have been no arrests made in the case, and his killer is presumably allowed to continue life as usual. You quickly learn when something tragic happens that seems to bring your world to a sudden halt, that the rest of the world continues to go on with or without you. And so it's our responsibility to make sure that his case isn't forgotten, but we also have to try to not give up hope that the case will be solved. Therefore, I'm asking the city again, and specifically the police department, to please exhaust every resource available to bring his killer to justice. That's what we want, is justice for Henry. I believe that the city not only owes that to Henry, but also to the rest of the city of Schertz, the entire city of Schertz, because this kind of crime isn't supposed to happen here. It's not supposed to happen here. And last year, our family retreated to avoid the pain and the reality that comes along with Christmas now. And this year, we're approaching it head on, and it's difficult. But that said, although it's unlikely that our holidays are going to be filled with joy, I would like to wish everyone here a Merry Christmas and a prosperous New Year. And thank you for your time.
Thank you, sir. Also have signed up this evening Mr. Glenn Outlaw.
Glenn Outlaw, 3729 Forsyth Park. A little reluctant now. My concern seems so inconsequential compared to what Mr. Gutierrez just had to say. I wanted to address the council about your special retreat on December 1st. I'll read you from the agenda. It says, call to order. Item number 1, discussion and appropriate action on city council and city staff team building, strategic planning, organizational development and structure, and proper governance. And then there's a bullet that says team building discussion led by Davis Success Solutions, facilitators and participants. Now, I'm sure as all of you are aware, I'm a very inquisitive person and I like to stay abreast of what's going on in city government. That's why I try to come to these meetings. And normally I would attend your special sessions. However, having attended these team building exercises, I really felt there was no need for me as a citizen to be there. So imagine my surprise when I read the minutes from that meeting and find out that during your lunch break, you were briefed on with information regarding the Marshal Department reorganization under the Police Department, Animal Services Department structure, and communications/dispatch over our position. Well, I have no doubt that the city attorney will tell me there was nothing illegal about that given the a broad caption to the meeting in general, I think it was inappropriate because any logical person would have looked at this posted agenda and assumed that it was a team-building exercise and not a discussion of other city business. I sometimes wonder why staff felt it was necessary to use that opportunity to brief you on that information. While I know those meetings are open to the public, they're attended by myself and Mr. Zewitt and, maybe one other person. Something like this would have been much better presented in an open, recorded forum like a city council meeting. Because now the problem is I can read in the minutes that Mr. Waite gave you that information, but that information is not in the minutes. In a meeting like this, I can note the minutes, and then I can go to the recording, and I can see and hear with the information you were provided. So I would just like to let you think about that. Again, I understand. I don't think there was any intent to fool anybody, but you put an agenda out there for a special meeting like that, and I purposely chose not to attend that meeting, knowing that it was your team-building exercise. Well, with that said, I'd like to echo Mr. Gutierrez's closing comments. Wish you all Merry Christmas, Happy Holidays, and I look forward to seeing you all in the new year. Thank you.
Indeed. Thank you, Chief. And also signed up this evening, Ken Greenwald. Mr. Greenwald?
Good evening, Mr. Mayor, Mr. Kessel, members of council. Apparently, your words on the signs for garage sales has already hit the newspaper, and everybody in the city knows about it. The garage sale signs are up all over the place. Worst part is 3 of them were in your city park, which I think is totally illegal. There were several others in various areas, not the right color, all assorted sizes, sticks, whatever you can think of. And this is only the first weekend, so imagine what it's going to look like in about a month. Have a good holiday. Thank you.
Thank you, sir. All right, I had skipped the workshops in favor of hearing of residents and giving them the preference. So I'll go back then to our regular agenda order, and we'll start with the first workshop we have listed, which is a presentation regarding records retention, public information, open meetings, and the use of social media by elected and appointed officials. And our city attorney, Mr. Zeck, has a presentation for us this evening.
Good evening, council. So I've never done anything like this from down here for y'all before, so I'm going to need assistance in getting my PowerPoint set up so y'all can see this. You'll have to excuse me. I've had over this thing for about 4 weeks now. So I think this is back and forth. Okay. All right. So we were tasked, our office was tasked with putting together a presentation on record retention, public information, open meetings, and social media. Our presentation, this presentation focuses on the law and not any policy-related issues, except to the extent the law would obviously dictate any policy outcomes. This is a very high-level view of the law. This is a complicated area of the law that has even more gray area than most areas of municipal law, just simply because much of it has not been litigated nor interpreted by the Attorney General's office or other administrative agencies who might interpret these issues. There have been some papers written on them, and a couple of the papers that we used, excuse me, in our office to assist in putting this together. I'm happy to share with y'all if you'd like to see them. So with those caveats in mind, I'll go ahead and go through this. When we're looking at the Open Meetings Act, or when we're looking at these issues, we're really looking at only a very small amount of statutory law and then the common law. So Texas Local Government Code, subchapter C, chapters 200 through, and they're up there, 201 through 205, deals with local government records, and it's the Local Government Records Act, and that's found in the Texas Local Government Code. And as a reminder to everybody, if you Google Texas Legislature, the first link that comes up is Texas Legislature. You click on that link. At that page, there's a link that says statutes. You click on the statutes, and all the codes will come up there, and you can click on local government code in them, and you can pull up these statutory documents very easily online. In addition to Texas Local Government Code, subchapter C, chapter 200, also local government the Government Code, chapter 551, which is the Texas Open Meetings Act, the chapter 552 of the Government Code, which is the Texas Public Information Act, the United States Constitution, the First Amendment, the Texas Bill of Rights, section 8, which deals with freedom of speech, and then, of course, common law, which is the court's interpretations of those issues. I did not include Attorney General opinions, mostly because Attorney General opinions, for the standpoint of controlling law, is not controlling. It's advisory to the courts, but it's not binding on anybody with respect to the law. The one exception to that is Texas Open Records decisions, but those really aren't as applicable to these circumstances as some of the other issues are, based on my understanding of what the issues are. Excuse me. So what is the definition of a local government record under the law? That's found in the Texas Local Government Code, Texas Local Government Records Act, and it's a very broad definition. You can read it. I'm not going to read it to you, but it incorporates almost any type of record that exists: electronic, print, photograph, map. It's a very broad definition of record, which would incorporate Facebook posts, Twitter tweets. Sorry for Twitter tweets. That's probably not right. But it's a very broad definition that would incorporate a multitude of records. And it's very broad, as you can see. And it's essentially anything that basically deals with the transaction of public business. What works with that, that broad term does not include notes, journals, diaries, and similar documents created by an officer or employee of the local government for the officer's or employee's personal convenience. So those types of things, even though they may include the transaction of public business, if it's for your personal convenience, the Act does not include those. Local government records are specifically subject to Chapter 552 of the Government Code, which is the Texas Public Information Act, and so that section of the Local Government Code works in concert with the Government Code, Chapter 552, the Texas Public Information Act. Basically, anything that's considered a local government record is subject to the Texas Public Information Act. Questions always arise, and used to always arise at least, with respect to, when you look at the definition of public records, and we'll do the Public Information Act, what that means, if it's not held by the governing body or not controlled by the governing body, by the city, then it's not a record subject to the Act or a local government record. And that notion was dispelled in a case that our office actually defended on behalf of County Commissioner Atkinson, and the court determined in that case that correspondence conducted through a county commissioner's personal email account regarding official county business constituted a local government record under the Public Information Act. So even though the correspondence was not through a city email account that was captured, controlled, and held by the governing body, the court held that that correspondence was still a local government record. And so by just sort of taking that logic to its conclusion in some other forms of communication, that would include Twitters, Facebook posts, blog posts, other things that response and to blog posts that might otherwise, that are personal blog posts that might otherwise you might not think be a local government record. So there's certain material that's not included in the definition. I've listed the main one. That's the personal diaries for personal purposes. The other two in section 201.038A are blank documents, in other words, forms that are blank, and copies of otherwise existing public records. And so any of those items that are not included can be disposed of at the discretion of the custodian or the creator of the document as applicable, subject to any policies developed in each local government. So what that means is that the city adopts a policy for purposes of disposing of local government records. That policy is the Texas State Library. Mr. Kessel, I'm sorry, you probably know it better than I know. The Texas State Library's archive requirements. And so we've adopted that. That particular document, which tells us when we can destroy records, is vague in the area of certain medias, like Facebook posts and electronic medias. It's basically determined by content as to whether or not it's going to meet the definition of local government record. And so each one of those would have to be evaluated. If you have a policy, which you should have a policy that dictates when those are considered to be a local government record, each of those have to be evaluated independently as to whether or not that creates a local government record, whether or not it's subject to retention, and for how long, exactly what type of local government record it is. Excuse me. So let's talk a little bit about the Texas Public Information Act. I'm sure all of y'all are very familiar with the act based on open records requests that have been made for the city. But essentially, it defines public information as information that is written, produced, collected, assembled, or maintained under a law or ordinance or in connection with the transaction of official business. And of course, one of the laws that would refer to is the Local Government Records Act, which dictates what a local government record is. And so that includes anything that is in connection with the transaction of official business by an individual officer or employee of a governmental body in the officer or employee's official capacity, and the information pertains to official business of the governmental body. Under the Texas Public Information Act, information is in connection with the transaction of official business if the information is created by, transmitted to, received by, or maintained by an officer or employee of the governmental body in the officer's or employee's official capacity, or a person or entity performing official business or a governmental function on behalf of the governmental body and pertains to official business of the governmental body. That's a very complicated way of saying that if you receive, for example, an email in your official capacity as a council member to your private email account, that is then going to be a document that is going to be subject to capture by the Public Information Act. More complicated, it's going to apply to Facebook posts if it deals with the transaction of official business. It's going to deal with an official Twitter feed of an individual, or potentially a personal Twitter feed of an individual if a discussion occurs on that personal Twitter feed of you as the council member, but it's not your official Twitter feed, but rather your personal, and it results in a tweet and retweet of official city business. The Public Information Act defines in what form a Public Information Act exists, and it, again, is very broad, just as broad as the previous definition that we had discussed. Excuse me. So this is out of a law article and I'll just read it, and it sort of talks about tweets or posts. So tweets or posts from a local government or local government department's account are subject to the Public Information Act. But what about a city council member's tweet? If the tweet is in connection with the transaction of official business, it is subject to disclosure under the Texas Public Information Act, just as I previously stated. Information is in connection with the transaction of official business if it pertains to the official business of the city, created by, transmitted to, or received by, or maintained by an officer or employee of the city, in that officer's or employee's official capacity, or as a person performing official business. And official business means any matter over which city council has authority or administrative duties. So if you're in your personal Twitter account, if you have one, I don't know how many of y'all actually have one, and you are tweeting about official city business, and people are retweeting that and responding to that, we are creating potentially a record, depending on how the content of those tweets, a document that should be captured, retained under the local records, and if requested under a request for public information, provided to the requester. The hard part, of course, is for everybody, and if you read some of these articles out there, and it's not unique to the city of Schertz, is how do you capture that stuff? How do you retain that type of information? How do we define what those local government records are, and how do we deal with it? The other thing that's affected by this is open meetings. So an open meeting is a deliberation between a quorum of the governmental body or between a quorum of a governmental body and another person during which public business or public policy over which the governmental body has supervision or control is discussed or considered, or during which the governmental body takes formal action. So note there, and all of y'all are familiar with this, that it doesn't require you to take formal action for a meeting potentially to have occurred. All it takes is a discussion of the quorum of a governing body over public business. And the most common example of this that is most often violated and most often creates problems for governmental bodies is the context of an email, whereby a public business is an email is sent out and it's not blind copied, and it deals with public policy or public business or the transaction of public business, and all council members are on that particular, or a quorum of council members are on that particular email, and someone does a reply all. And as a result of that, have we now created a meeting in violation of the Texas Open Meetings Act? The Attorney General says that you have, right? And so that is out there. And that's the biggest violation that we always see, or potential violation that we always see. But it can occur in the context of social media as well. A Facebook post. Does the like of a Facebook post by a quorum of the council members, a Facebook post that deals with the transaction of city business, is a like by a quorum of the council members a meeting? I don't know the answer to that question. I can tell you it's debated amongst city attorneys and others. I can tell you that 2 cases exist on it with respect to whether or not a like of a Facebook post is an expression of speech for purposes of the not the Texas Open Meetings Act, but Open Meetings Act and the First Amendment. So those discussions are out there. And the answers, I can't give you the answers to them. I don't know the answers. I wish I could make y'all's jobs a lot easier. But those things are out there. And they are things that you have to consider and think about. So, of course, the term does not include the gathering of a quorum of a governmental body at a social function unrelated to public business conducted by the body if formal action is not taken, and any discussion of public business is incidental to the social function. Communication or exchange of information between members of a governmental body about public business or public policy over which the governmental body has supervision or control does not constitute a meeting or deliberation for the purposes of the chapter if the communicating is in writing, it's posted on an online message board or similar internet application that's viewable and searchable by the public, and the communication is displayed in real time and displayed on the online message board or similar internet application for no less than 30 days after the communication is first posted. What does this mean? This was an addition to the Texas Open Meetings Act several legislative sessions ago because of concerns about the ability of council members to comment on social media outlets. And so the Texas legislature created by statute an online message board that has specific requirements that have to be met, but would authorize a quorum of multiple council members to comment on those issues if it meets the requirements of the statute. I'm going to give you a quote from, here it is, I just jumped to it. This is from that article. Now, this particular lawyer says Facebook may satisfy the requirements of 551006 to meet the requirements of an online message board. Our law firm, quite honestly, disagrees with that interpretation. We don't think Facebook is set up in a way that would meet the requirements. For example, perhaps I'm just technologically unsavvy, but I'm not aware of a way to search Facebook for a particular post to determine if that post exists or not. And so that's just one example of why I don't think it meets it. But if it does, you can only have one. You can't have multiple. So you can't have a official City of Facebook page that authorizes a quorum of council members to post on it, and then have a separate online message board as well. The statute is very specific. You can only have one. And that's what the previous slide says. A governmental body may have no more than one online message board or similar internet application for the purposes of those communications. One thing that Dan Santee included in this presentation and I had taken out because it can really, really get into the weeds, but I'm going to go ahead and touch on it briefly before I move on to the First Amendment. That is that it is possible that you can create under the cases, governmental bodies, when they regulate First Amendment, they can create specific types of forums. A traditional public forum, an example of a traditional public forum is the sidewalk outside City Hall. And you have very limited means to regulate someone's speech on the sidewalk outside City Hall. However, there are other forums considered a limited public forum, where perhaps the governing body creates a forum where speech can be regulated in a particular way because it's created for a particular purpose, and so it can be regulated more stringently than other public forums. However, it is possible for limited public forums to be turned into a traditional public forum. And so that comes up because the question is, if you have an official Facebook page and someone posts something on that Facebook page that somebody doesn't like and it's deleted, is that a violation of that person's First Amendment rights because we have deleted the Facebook post? Because we have now created a traditional public forum which is subject to strict scrutiny under the First Amendment standards as to freedom of speech. And so those are things that we have to look out for and deal with when we're dealing with social media. That's why I said at the outset, we could really get into the weeds about what some of this stuff is, so this is a really high level just overview. But those are issues that we have to work out, we have to think about. Same with a Twitter feed, an official Twitter feed of the city. If we're not limiting how people can comment on that and what they can comment, then it's very possible, there's no cases on it, but it's possible that we've created a traditional public forum, and deleting people's tweets off of that Twitter feed could be a violation of their First Amendment rights. So let's talk about the First Amendment. Everybody knows what it says. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. Right? That's what we're talking about right now, is abridging the freedom of speech. And what does that mean in the context of social media and the regulation thereof? So this is specific to I think a future discussion that y'all are going to have with respect to social media and ethics policies, potential ethic policies on the limitation of the expression of elected official speech, is my understanding. And this particular part of the presentation goes directly to that. So the United States Supreme Court has held that in order to compel the exercise or suspension of speech, that is, in order to be in violation of someone's First Amendment rights, the governmental measure must punish or threaten to punish protected speech by governmental action that is regulatory, prescriptive, or compulsory in nature. In other words, it has to be in the first instance, it has to be a law, right? A rule or a policy is not sufficient. The consequences of that regulatory, prescriptive, or compulsory regulation is that there must be an indirect, the consequence can be an indirect discouragement rather than a direct punishment, such as imprisonment, fines, injunctions, or taxes. Right? So in other words, it doesn't have to be direct punishment, but it does have to be punishment or indirect discouragement. However, a discouragement that is minimal or wholly subjective does not impermissibly deter the exercise of free speech rights. Now, this is from the United States Supreme Court. Let me take a break here and just say briefly, most lawsuits, the way they are brought, if someone alleges an abridgment of someone's First Amendment rights in Texas, they're going to bring two causes of action. They're going to bring one, the first one is going to be an abridgment of their Texas constitutional rights under the Bill of Rights, and then they're going to bring a cause of action under the United States Constitution, an abridgment of their rights under the First Amendment. The law is that before the federal constitutional issues can be dealt with, before the state constitutional issues can be dealt with, the federal constitutional issues have to be dealt with. And so first there will be a determination as to whether or not there's a violation of the United States Constitution's First Amendment, and then if there's no violation of that, there would be an analysis as to whether or not there's a violation of the Texas Bill of Rights. Generally speaking, the Texas Bill of Rights have been analyzed fairly consistent with the federal constitutional requirements. However, there is case law out there that says that it is possible that the Texas Bill of Rights could expand someone's rights for free speech under the Texas Constitution. Perhaps where it's not a violation of the federal Constitution, it could still be a violation of the Texas Constitution. Or, does that make sense? So, as a governmental entity, when we're talking about the regulation of speech other than private citizens, which is a whole different standard that I'm not going to get into, we're really talking about regulation of speech of our employees and regulation of speech of our elected officials and our appointed officials. So with respect to city employees, governmental employees, there is a test. It's called the Pickering balancing test. And it is used to determine if the speech of a public employee is protected by the First Amendment. A local government, a city specifically, may terminate an employee for speech, all right? But it has to meet the Pickering balancing test in order for that to occur. And so what the Pickering test says is that we first determine whether or not the public employer's penalized speech was for the purposes of engaging in something that was in the interest of the employee as a citizen in commenting upon matters of a public concern. So the first question we ask is it a matter of public concern? Is that the reason why they were terminated or disciplined? And then once we determine if it was a matter of public concern, the next question is, was the interest of the governmental agency as an employer in promoting the efficiency of the public services it performs, was that interest greater than the public concern that was being discussed? And the court will conduct, and I'm not going to get into all the different factors that it considers, but the court will conduct a balancing test as to whether or not the speech is then protected for purposes of being protected or not. If it's not a matter of public concern, then it's not protected speech for the purposes of disciplinary actions against employees. So, with elected officials, how can elected officials regulate themselves? Well, we know that the Texas legislature has done that, right? Through a little bit through the Texas Open Meetings Act, correct? If you get together as a quorum of a governmental body and you talk about public business, that is a crime, right? So that's a punishment. And that's clearly regulating the speech of elected officials. So it can be done, and that's very clear. However, with respect to what I consider to be local government officials regulating themselves, I mean, clearly if we attach a punishment, a true punishment associated with the regulation of elected official speech, it's my opinion that that's going to be, depending on the facts, very possibly it's going to be a violation of First Amendment. There is no on-point Fifth Circuit or Supreme Court precedent on this issue, and I say Fifth Circuit because the Fifth Circuit courts is the circuits that the state of Texas is subject to. That's the law we look to. However, believe it or not, there is some case law out there in other circuits that have dealt with these issues. In the 10th Circuit and the 6th Circuit, those courts determined that the mere censure of an elected official for violating an adopted ethics policy is not a violation of the elected official's First Amendment rights. In those cases, there was ethics policies adopted, there were violations of those ethics policies, and the city council simply censured the council member by saying, don't do that. It's essentially a reprimand. That's not a violation. That, by those court standards, not a violation of their First Amendment rights. Also in the 10th Circuit, the removal of an elected official from appointed boards and commissions did not limit the elected official's free speech. It was a situation where the elected official was actually removed from appointed boards and commissions as a result of speech. And the court said that they don't have a right to sit on those boards and commissions. They could be removed at any time without cause, and as such, it's not an abridgment of their First Amendment rights. Where I think that would be different is, for example, in the state of Texas, zoning board of adjustment members specifically may only be removed for cause. So they are not a board or commission that can be removed without cause. You have to have specific cause to remove them. And I don't know what a court would do, but my gut tells me that if you were to remove a zoning board of adjustment member for speech reasons, that could be problematic. So the Eighth Circuit is the only court where I could find where there was actually where we could find that there was actually an overturning of punishment against the member of a board. And in that situation, it was an ambulance district board, and they're elected representatives. And that board adopted a resolution which specifically limited that board member's participation in board activities, both in speech and in the nature of their activities with the board. And the court held that that was a violation of both their First Amendment right and their 14th Amendment equal protection rights, and that the resolution created standards so specific to the member and didn't apply to anybody else, and she was so treated differently that restrained her interaction with other members, that was an abridgment of her First Amendment and 14th Amendment equal rights protections. As far as we can tell, those are the only ones out there that specifically deal there are others that deal with similar issues, but they're not really directly on point, and so I didn't really get into the weeds with those. So just a brief summary of this very high-level look and dense, as Mr. Kessel and I both discussed, and I'm happy to answer any questions. So for city council members and appointed board commissioners, just like private email accounts used for public business or text messages from a private phone about public business, internet postings on a private account regarding public business are subject to the Texas Public Information Act. The question then is retention, and how do we do that? So once requested under the Texas Public Information Act, internet postings from a private account would then become subject to the retention if they were not subject to retention already due to content. And that goes back to my original statement, which is each posting is going to, factually, you're going to have to look at it, determine as to whether or not it's a local government record. However, even if it's not a local government record, it still could be subject to the Public Information Act under the definition of public information, and the minute it's requested, you can't destroy it, and it needs to be turned over. We have one online forum that does not violate the Texas Open Meetings Act, and that's the one that's discussed in the statute that requires very specific things to be set up to maintain the records, and it's got to be searchable, and it's got to be one click away from the website, and all sorts of requirements, but you can only have one. And if you have that, you can have a quorum of council members discuss an issue of public business and not violate the Texas Open Meetings Act. Otherwise, there's a real question with respect to quorums of council members liking Facebook pages, liking statements that have to do with the transaction of city business, retweeting each other's tweets if they have to do with the transit. Is that a violation of the Texas Open Meetings Act? Do you have a quorum of city council discussing city business at that point? Speech of elected officials and government employees may be regulated within the constraints of the First Amendment and the cases interpreting the First Amendment. So we can regulate the speech of elected officials and government employees. However, that regulation has to be within the constraints of the case law that deals with the First Amendment. Finally, only City Council can govern the City Council's social media activity, other than in the event of a violation reported to the Office of the Attorney General, and that would be the event of a violation of the Texas Open Meetings Act, for example. That's all I have for the purposes of my presentation. I realize it's dense. I realize that it's could be difficult to follow. There are hours of CLE that people go through to deal with these on a regular basis. But I'm happy to answer any questions that you have on the law.
Cool. That was my question, is since it was just listed as a presentation, if it was okay for council to ask.
I'm okay with it. I don't.
As long as you're okay with it, then I'm good with it.
I'll answer them to the best of my ability. If I can't, I'll tell you I can't.
Sure. Council questions for Mr. Zach.
Mr. Mayor.
Mr. Edwards.
I just have one word: convoluted.
Yeah.
It's extremely convoluted. So personal pages, all those things. You were saying who's tracking whether the document or the post is going to be viable for record retention? There's no tracking of that.
No, there isn't.
So
who's tracking? I'm going to answer the question by asking another question. Who's tracking the personal emails of the individual council members that get personal emails that deal with the transaction of city business? The answer is the same. If it's a personal Facebook page, then it would have to be the individual whose Facebook page it is. And what we do as the city, when a public information request comes in, and I think y'all have received one of these letters already, if a request for public information comes in that says we would like a copy of all emails and text messages dealing with this issue, we send a letter to the city council, each individual city council member, that says a request for this information has been made. Please search your private emails and private cell phones for information that is responsive to this request and turn it over to the city. And if you don't have any, please sign this document that says that there isn't any. What we effectively done as the city is place the burden on you to not destroy that information and to turn it over. And if you don't, and it exists, that's on y'all. But we've protected the city, which is all that my job is to protect the city. And so I think that we would do the same thing with if someone made a request that it would include any and all Facebook posts. We would send a similar letter.
So, Mr. Zach, so a simple disclaimer saying these are my views alone. That's not covering it then.
No, you don't get to take off your
the mantle.
Council hat. You're an official. You're an elected official of the city of Schertz, and if you're posting information about the transaction of public business, if you say these are my views and my views alone, all you're saying is that I'm not representing the views of the entire elected body, only the views of myself as an elected official. But that doesn't change the nature of the information.
So social media has come along and changed everything
Tremendously.
Yeah, and so there's no real answer.
Well,
besides the fact that there's no answer.
Yeah, there is no. I mean, there are some things we have answers on, but there is a lot that we don't. And I can come up with what I consider to be common sense within the structures of the law answers to the questions. But, archiving this information, capturing this information, determining whether it needs to be retained, how it's retained, that's very complicated, and it's not easy. I mean, we can do it with our official Facebook page, all right? We can do that. But with respect to individual Facebook pages or in official individual council member Facebook pages, clearly it's a lot more complicated.
Thank you. Others? Mr. Crawford?
Mr. Zek, is what you presented available for us to peruse at our leisure?
Sure, this is an open
The
document.
city's got it?
Anybody can have a copy of it.
Thank you.
All right. Anyone else? Dr. Scagliola?
Zach, are you involved in developing the training citywide for our employees?
I personally am not.
You are not.
Our office is.
Okay. All right. When do you estimate your the analysis and the presentation will be completed?
For training for council members?
Well, for training in general.
Well, so perhaps I'm confused. It's my understanding that there's going to be a discussion by this body with respect to a policy that's going to be created. Mm-hmm. We can't train anybody on anything until we have a policy.
Okay, but there is a policy already for city employees.
For city
right?
employees, and to my knowledge, we're not involved in that.
Oh, okay.
I don't know. I'll defer to
all right,
Mr. Kessel.
So there's a policy related to the official city social media accounts, and it applies to not only city employees but to council, boards, and commissions, that kind of thing. It is probably not what you would need a lot of training for, other than we manage those. It has to go through a central office. And there's a reference in it to our normal personnel policies. It's already been reviewed by the attorney. So anything that you would get in trouble for doing in a different format, you could also get in trouble for doing on that format. And to that extent, it has been reviewed as a HR policy, if you will,
sure,
by the attorneys, but is distinct and separate from the policy the city council is discussing whether or not they wish to have related to elected and appointed officials and social media.
I'd very much like to see the any type of training that we intend to offer to employees in the city, because I think a lot of times we have the policies in place. We just need to dot the I's and cross the T's. The stuff already exists, so we don't need to reinvent it. And I'd very much like to see the completed proposal for training before I even went down the road of enacting anything for the city council. That's my personal opinion.
All right, Mr. Larson.
Sorry, I enjoy these kind of conversations too much. So some of my questions, I think I know the answer to, but it's so complicated.
It's very complicated.
Can you help me, define a transaction of official business? And the reason let me give you context of what I'm trying to understand. Let's say I have a personal page that's just a personal page. On it, I don't say anything about my elected position status. And I say, happy birthday to my daughter. I would imagine that's not a transaction.
That's an easy one.
But if I have a personal page that I've set up specifically as an elected official to communicate with constituents, and it says Schertz City Council, Place 3, and on that page I say, happy birthday to my daughter.
I have been successful in arguing to the Texas Attorney General in the context of emails on city email accounts that those types of information are not city business.
Okay.
Subject to the act.
And then, now what about if it's on my personal page with no reference to my political position, and I say a broad political opinion such as I hate property taxes.
I don't know the answers to these.
Well, no, that's okay. I understand, and I don't know is a completely acceptable answer. I don't have a point other than I'm trying to understand what we do know.
Yeah. So I don't know the reason why. Let me tell you why I don't know the answers to some of these questions with respect. Like, that's a good gray area question.
No.
I think I could make an argument on both sides. I don't get to make that decision, though. Under the law, if someone makes a Public Information Act request and we don't think that it's either A, subject to the Act, or B, there's an exception for it, the only person who gets to make that decision is the Texas Attorney General. So we would have to take that statement. We would have to then submit it to the Texas Attorney General and say, we don't believe this is subject to the Act for whatever reasons. It's not the transaction of official city business. It's not anything you have control over. We would make those arguments, and the Texas Attorney General would tell us whether or not it's subject to the Act or not.
Okay. And then, I guess, what if I don't know, I don't want to get too bogged down in hypotheticals. I'm just trying to understand where because I know that gray area, I'm trying to see how wide the gray area is.
Pretty wide.
Is there any difference between if I'm acting as a person campaigning for political office versus somebody who is commentating as an elected official? So, for example, let's say I'm not on city council, but I say so-and-so voted this way on this particular city business, and they shouldn't have, and this is why.
Not subject to the Act.
That is?
It is not.
Not. Okay. Now, if I was campaigning for re-election and made the same post, it would be, though. Is that correct?
I would argue that I would think that it probably was. I've never been in a situation where someone has made a request for that information. In other words, did you put it on your Facebook page, or did you send it in an email to somebody, and then somebody made a request for that type of information? I've never seen a request for that type of information, and I've never seen an Attorney General opinion that addresses it. One may exist, but I don't know.
And then the final question, just to understand the difference between real life and social media. If I were to rent a stage and get a bullhorn and discuss in detail city policy as an elected official, would that be communication that's official, transaction of official business that would be subject to records retention? And
I don't think I understand your.
so, let's say I'm doing the same speech that, instead of on Facebook writing, "Hey, this particular thing is going to be on the agenda, and this is what I think about it," I rent a stage and I put it in Pickerel Park, and I grab a bullhorn and I shout the same exact thing into the air.
Did you record it?
No, I'll just say no.
Well, there's no document that would.
Understood.
There's nothing that would.
Well, that makes sense. All right, thank you. I still have no idea what I'm talking about. But it helps a little.
Mr. Zek, I do have a question for you. All these things that we've discussed, do they apply to the members of the state legislature?
No.
I didn't think they did. I just wanted to point that one out from our friends in Austin.
Yeah,
Applies to everybody but them.
Yeah, it's convoluted because you have to think about what's a local government record, what is a record that's subject to the Public Information Act, you have to think about that in the context of social media. Then you have to think about the Texas Open Meetings Act, and are we a quorum liking each other's official statements about city policy? Is that a violation of the Texas Open Meetings Act? And then the First Amendment issues associated with those things when citizens start commenting on Facebook or Twitter or other places. And what if we delete those comments because we don't like them? I mean, there's so many different moving parts associated with this that we have to keep our eye on. And, that's why I give such conservative advice when it comes to the Texas Open Meetings Act and those things. Like, don't hit reply all. Don't be friends with your council members on their official or personal Facebook pages. Don't follow them on Twitter. Some folks don't like me because of that conservative advice, but because I don't know what some of these outcomes are going to be, that's by far the safest approach to take.
That and the fact that you've told us before that the only ones that go to jail are the elected officials.
Yeah, I don't go to jail.
Not the lawyers.
I don't go to jail. And I'm not a criminal defense lawyer, but I know a good one, so.
I don't want to have to ask you who that is.
But to be clear, there's very few times you can actually go to jail for violating the Open Meetings Act or the I don't think you can go to jail for oh, you can, destruction of a government record. So yeah. I mean, there are times, there are few, but they do exist. They do exist. Having a closed meeting without authority, that's a jailable offense. 6 months in jail.
So I think that one of the things that we've learned from the presentation is that this is no simple undertaking for the council to embark upon in determining if we're going to write some guidelines, potentially develop a policy, et cetera. There's probably a lot of work in front of us. But I do think I heard you say that having some sort of set of guidelines and training is advised from our attorneys.
Well, yes, but I say that in a limited context. I mean, because there are certain things that are a little more concrete, and we can deal with policies. Certainly, when it comes to city employees, I mean, it's much easier. When it comes to elected officials, there are certain things that are more concrete. For example, create a policy that says people cannot be friends with other officials on their Facebook pages, right? We know that's a conservative approach that is so that nobody's guessing and has to think about it. We create a policy that says it, and then everybody goes, yeah, that's a good idea, and we're all going to abide by it. So I say that within the context of some of the concrete things that we know about. That's to make that clear.
Gotcha. All right. Other questions for Mr. Zek? Mr. Edwards?
So unfriend.
It's always my advice, but it's up to you.
Yes, Mr. Zek has told us before that he will give us good advice, and we are at liberty to fail to take it.
Thank you. Unless there's no more questions.
Any other questions for Mr. Zek at this time? Okay, doesn't appear there are. Thank you, Mr. Zek. I appreciate that very much. Next item that we have on the agenda this evening, we have discussion and overview regarding the speed hump process. All right, evening, Ms. Paloma, how are you?
I'm well. How is everyone?
Very good.
Good evening, Mayor, City Council, Mr. Kessel. So it says here discussion and overview for speed humps. So I have a PowerPoint ready, and the PowerPoint is specifically to what was requested on October 24th, which was an overview of the speed hump process. So we'll start with the basics. So in our Code of Ordinances, in Article 9, speed humps are specifically discussed. They are also defined, and it is a gentle rise and fall over a pavement surface, and it's placed on a roadway to reduce the speed of vehicles. And there are also eligibility requirements for speed humps, for the installation of a speed hump. So there's several requirements. I listed the three most important here. The street must be a residential street. It must have a speed limit of 20 miles per hour. And the traffic volumes, the minimum volumes are 500 vehicles a day. And there is also an application that is required to be submitted by a citizen. And I have that on the next slide. But the engineering department works with TSAC, the Traffic Safety Advisory Commission, and we work with them for other transportation issues, but we bring to them the applications that have been submitted to the city, and we also work with them and let them know how we review an application. So specifically, the application itself is the formal request for a speed hump or traffic calming study in the city. And so these are two of the most important pages from the application. The pages include the ordinance and the sections that I included in slide 2. But also signatures are required from residents on that street in question. And the purpose of that is because we believe that, well, the requirement is there because the community as a whole needs to be an advocate for that request or study. And then if it does get installed, the community as a whole has to agree onto where it's going to be placed on that street. So that way we don't go to just one citizen's cry for help. We have to get the community involved as a whole. So 3 departments work together to review this application, engineering, public works, and the police department. And so the exhibit here on the right shows a GIS layer file that we use to keep track of traffic counts, because we put out traffic counters which record the vehicle volumes, also their speed, and we record over the duration of at least a week, so 7 days. So we get an average daily traffic count. And so if you look on the right, it'll say, for example, we did a study on Wiederstein, so the average daily count was almost 14,000 cars. And so it gives, this specific exhibit shows the volume for the week, but we can also get the speeds. We can also get the type of traffic, an 18-wheeler, a motorcycle, a truck, a car, so it can track that. So the police department, what they do is they go out there and monitor the street and do, law enforcement, but we also get any type of, the amount of tickets, accident reports filed on that street, and so we take that into consideration. Other staff departments also perform site visits for things like perhaps there's a missing stop sign, perhaps the pavement markings are worn, perhaps there's another issue, like if there's a park close to that street, so that can affect the vehicle trips on that street. And so if people that don't live on that street don't pay attention to the speed limit sign, if it's missing, we need to identify that, install a speed limit sign. So there could be other problems. So we try to look at the request as a whole and not just jump to, we've got to install a speed hump. We also look at pedestrian traffic, bicycle traffic, cut-through traffic. A good example would be Belmont up by 1103. A lot of people are using Belmont to cut away from the 1103 construction. So we've got an issue with that right now. Curbside parking, and then we use alternative solutions as well, like speed trailers, and then we reach out to the HOAs for community involvement and education. And once we gather all this data, we see if the application and the criteria are met to install a speed hump, but we also use other installations of, like I said, the speed limit sign, maybe it's missing, perhaps there's something else going on that is causing people to speed on that street. Part of the ordinance identifies the speed hump detail. There's a requirement for it, and that is because our emergency vehicles cannot get over a speed hump if it's taller than 3 inches. So that is a restriction for our emergency vehicles, so that's one reason we only allow it on residential streets, because our emergency response teams has to be able to get to an emergency as quickly as possible. Also, the street sweepers, the street sweepers are so low, and they have broom bristles at the bottom of it, and it can only rise so much. So if the speed hump is taller than 4 inches, then it won't be able to clean that street. It'll have to do a turnaround. And so that's why we have this speed hump detail, this technical specification, and it falls in line with what other municipalities do, not just in Texas, but all over the country. So one thing to recognize is that once you install a speed hump, sometimes people believe it will slow them down so much that they have to take an alternate route. So sometimes what happens is if people recognize there's a speed hump installed, they just go to the next street down. So then we get people from the next street call us, and so that would not be a permanent solution, which is why we look at other avenues to fix the problem. So like I spoke earlier, perhaps striping, speed limit sign, things like that. If a speed hump were to be installed, we recognize that there could be advantages and disadvantages. So the advantages obviously would be to reduce vehicle speed. It can reduce vehicle volumes. And the advantages is that it does not restrict on-street parking like chokers or restrict parkings in general to keep people from using a residential street as a thoroughfare. Speed humps require minimal maintenance and they're fairly inexpensive. They can be removed and relocated if needed. But some disadvantages are, like I said earlier, individuals that recognize a speed hump is installed will just find an alternate route. They are not aesthetically pleasing. They can even be noisy. And they increase emergency response times because not only do we have to slow down, but emergency vehicles will have to as well. So we discourage installations sometimes for that purpose. And they are not always desired by motorists. If a speed hump meets all the criteria, and we've done everything that we could to help minimize speeding, we send a letter out to the applicant and the individuals on the application that sign the form. And this particular one, I don't recall where it was at, but it was one of the few, it's Scenic Links. It met the criteria. And so the one part that our citizens don't like is it takes time to do this study because we don't want to jump the gun. We want to make sure that we're looking at all aspects of this particular street and issues. So once it meets, we send out a letter saying it was approved, and then we move forward with purchasing speed humps and installing them. And we do inform the applicants about when we're going to install them and the locations. Currently, the city of Schertz has 10 different locations where speed humps are installed. There's 2 in Covers Cove. It's up at Northern Hills, just past Northern Hills communities. 1 at Scenic Links, 2 at Morning Drive, 2 in Hiley Heights, 1 at Jonas Drive, 1 at Greenshire, and then there's 1 at Circle Oak Drive. And the picture on the lower right is the speed hump that we installed at Hiley Heights. There's 2 of them. That stretch of road is over 1,500 feet long, I think, and so we had to install 2 because the length of road was so long. A typical residential street is like, I think, 700 feet long. So that particular street was quite long, and so we had people that thought it was a thoroughfare. So we installed 2. Okay.
Very good,
Any
Counsel.
questions?
Questions? Mr. Gutierrez.
You said you installed 2 on that. What's the distance? What do you determine would be the distance between the 2?
So for that particular street, I don't remember the distance between the 2, but the ordinance reads that there has to be a minimum distance of 750 feet, which is conservative. Some cities require more, some less. So we put a mid-block. Hiley Heights does have a street that intersects mid-block in that long stretch of road, so we put 1 on each side of that T.
All right, anyone else? Dr. Scagliola?
Speed humps are generally designed to slow down the traffic.
Mm-hmm.
Now, I see they are a little bit costly, about $2,500, and even though if the problem doesn't persist, you can take them away and put them someplace else.
Mm-hmm.
Have you actually explored other options for slowing down the traffic, like those little rattle things? I remember when I was stationed in Germany, coming up to some of the stop signs, there were cobblestone streets. Hitting a cobblestone at about 20 miles an hour will rattle your teeth. It'll give you something to think about. Do we have any kind of options like that? Because I've noticed that sometimes people pick up speed without really intending to, and without any good calibration in our brains that tells how fast we're going, other than looking at the speedometer.
Sure.
Sometimes we
get comfortable.
Yeah. Is there any other? Are there any other perhaps cheaper options that can be explored?
So the cheaper option is that we go out and do site visits and we explore and see if there's something else going on. So one issue that we have here in the city because of growth is that we have a lot of construction traffic. And so, they don't always recognize our speed limit. But we do look at other things, signs, striping, community outreach, education, law enforcement, because really what it is, it's a law violation. And so we are also looking at, there's nothing in our ordinances or our development manuals for us to incorporate traffic calming, but we're working on that. It's actually, we've had a lot of great ideas. It's just a matter of deciding which is best for the city. But we haven't explored what you've talked about, but we've talked about rumble strips. Striping is fairly inexpensive. We've discussed getting a thermo machine and striping appropriately. So yeah, there's always that discussion. We just need to move forward with what's appropriate for this city.
Now, when you say you go out and you do site visits, I mean, big old trucks coming through a neighborhood to avoid other intersections. That's an obvious, attempt to get around using the roads correctly. We should be able to stop that. I recall getting an email from a resident up in Belmont Park that says they've been having that problem.
Sure.
That should be easy enough to fix.
Sure, but the thing with those situations is that it's not illegal for them to use a public street. What's illegal is that they're speeding or they're not stopping at a stop sign.
Okay.
And so actually one of our PD liaison, he lives up there, so we get input from him often. And he has said that there is a lot of truck traffic, but the best thing is enforcement, so he's out there quite a bit.
Okay. So in your estimation, looking at these, going out to the different sites, what is the biggest cause of speeding in our communities?
People don't obey the law. Sorry, that's what we've observed.
And the solution to that is? What do you think?
Well, I think the solution is education, because people become comfortable.
Mm-hmm.
And then second would be enforcement, I think.
Okay.
Yeah. But we also incorporate other things, like I said, striping, signage, community outreach, I think.
Okay. Sounds good.
If I may, Councilman, too, and we've talked about this as well. What we're trying to do with traffic calming, whatever the solution is, rumble strips, bumps, chokers, speed humps, is fix a problem we already have. And so really one of the things that we have worked a lot on is try to, when we look at subdivisions coming in, new subdivisions coming in, the planning department, engineering that go before planning and zoning commission, or identify those areas we think there is likely to be speeding because of those site visits we've done. So for example, when you have curves on a road, a vertical curve, people tend to gather speed there. The street up by the water tower up north, we've had scenic links. You come downhill, you tend to pick up speed. Jonas Woods, we have a bit of that as well. Long straight shots, you tend to get speeding. Ironically, if it feels wider, you get speeding. So one of the issues in Laura Heights is those are large lots, half acres, so the houses tend to be set back a little more. They've all got long driveways, so very few cars parked on the street, and it's a straight shot. So people just tend to fly. So one of the solutions is look at those things on the front end and try to look at where we would have it and make adjustments. So P&Z sees that at times, and that's what we look at. I will say one thing keep in mind, though, is we as a community have set a 20-mile-an-hour residential speed limit. Probably been to other communities that have a 30-mile-an-hour residential speed limit. So in San Antonio, for example, in residential speeds, it's a 30-mile-an-hour speed limit. Many communities are that way. It's just a choice. But you can imagine where we would look and say we have a problem at 25 miles an hour, 85th percentile. San Antonio looks and goes, well, this is pretty good. So one of the challenges we have, and I think this is just a reality, so I don't want to not mention it, is because we have set a low speed limit, we're trying to get enforcement and compliance at that rate. So there are some challenges to that. And again, I would encourage you, when you go home tonight, at some point, as you're driving in your neighborhood, stop down and look at the speedometer, and it's really easy to get above 20 miles an hour. Again, you get up to 30, you ought to know it. But that's what we see a lot, is there are a lot of folks who are speeding. It's just, do they rise that 85th percentile? So I think that creates some issues we just need to be cognizant of, which is why I think design on the front end is all the more important.
Mr. Mayor? Did you have anything else, Dr. Scaglione? Mr. Davis? And we'll come back around.
Yeah, having spent quite a few years on the TSAC, I'd like to commend the staff for their current process that they have. I think it's a very deliberate, very thought-out process, and I remember when I was on the TSAC, we brought up that issue of being proactive and looking at new developments and seeing if we can stem that problem before it becomes a problem. I can tell you that just putting out speed bumps doesn't solve anything. The mayor will attest to it. We live in a gated community. That is, you've got 10 speed bumps in the city of Schertz. We have 18, last time I counted, in Carolina Crossing North. And we still have neighbors complaining about people speeding through the HOA. So putting out a bump in the road doesn't really solve anything other than create more headaches for all other kinds of things. But I'd like to, like I said, commend you on the process that you have there, and I think it's working out pretty well for the city.
Yeah, putting out stop signs in our neighborhood doesn't make any difference either. It's totally ignored. Mr. Edwards?
It's so true. So whenever there's new construction going on, we always tend to have people call and say that people are starting to cut through their neighborhood. We had that at Laurel Heights. We've had that at different communities throughout the years that I've been on council. I've seen that every time. So I think maybe discussing that even in greater detail prior to the site development may be beneficial. One thing, you said the vehicles are speeding. We understand that, but are these trucks that are cutting through the neighborhoods, do we have units that can actually weigh those trucks? Because they could potentially be overweight for that residential street. Oh, Chief is shaking his head. Is that even allowable by our city?
We don't weigh them, but we know what they can and can't weigh, and they have to have a permit for a specific weight.
Okay.
So our police officers, they know that. They're trained to check for that. But
Okay.
we don't have an actual weight to weigh them.
Because typically, don't you see 26,000 pounds ridden, or 13,000? 15,000. And that does damage our street if they overweight. 20 miles an hour, is that legally enforceable? Because I was under the impression that 25 was the, or am I wrong here? Chief, anybody can help me out. Is that
Well,
legally
it's an ordinance, so it's legally enforceable.
And it'll stand up to state statutes as well? I'm just asking.
So there are some, well, sorry, it's just like I thought he wouldn't get up, and there are state statutes relative to speed limits that restrict us in terms of requiring a study and things like that. So again, we are not free to do whatever we want, how we want with regard to setting residential speed limits at whatever amount. The state does place some limitations on communities, and those can be a challenge to meet, and that's probably why some communities maybe have some higher speed limits.
Thank you. I just thought I'd ask. Good job, guys.
Mr. Crawford, you had something?
Mr. James.
Hiding spot in the corner.
Sorry. I remember on P&Z we did some discussions about heavy trucks going through Haley Heights and Laurel Heights streets and some other streets out there in Houseman's project, where we put up some signs that they shouldn't be going on these streets because they're residential streets and they should be coming through a different entrance or exit. Was that, I don't remember, was that UDC approved, or is that just a policy we put in place for a subdivision being in development stage?
It was UDC based. So again, what we had in the Laurel Heights, Howley Heights, is they requested a waiver to only have one point of access, one street point of access. And so when those waivers are requested, the Planning and Zoning Commission can impose conditions. And the condition was that came through, I think when it came to council, was that it limited truck traffic. So we normally do not have the ability to do that. As Cecilia said, I think we've got two kinds of issues. One is we've got that truck driver's not going anywhere in that neighborhood like Belmont. He's just cutting through to get from one place to the other. The other problem we get are that initial phase gets built, and then residents of that first phase get very frustrated that trucks are coming through to get to the second phase or the third phase. And sometimes there's an alternate route, sometimes there's not. We have worked with some developers to try to do that. In that case, we contacted Cibolo. Cibolo's Development Services Department put out the word to their builder's developer, hey, we're getting complaints in Schertz, you need to go a different route. We have worked with the developer of Homestead to limit truck traffic coming through. And I've gotten a couple calls saying, hey, they're moving the barriers, come through, and I've called the guy back up, and they've tried to deal with it. So it's worked to some degree, but we generally do not have the ability to restrict truck traffic that their destination is in the neighborhood. That's just an inherent problem.
Thank you. The other comment is next time I buy a car or truck, I want to make sure that this cruise control works at 20 miles, not just at 25 and above. That might help me a little bit.
All right, anyone else? Very good. Thank you for putting this together for us. And if we have further need for discussion and we talk about adding things to an agenda, we should do so at that point. You had something else?
And Mayor, if I may, one bit of kudos, I think, to echo Councilman Davis' comments. I think city staff and police, engineering, public works have really stepped up over the year to try to really get more sophisticated, gain more knowledge, and get better. They really have done a good job, to the degree that we're going back now and doing a second set of counts where speed humps are installed to try to look at the effects. So again, if you really are interested, we can show you what was going on in Laurel Heights beforehand and what's going on now, which again is a bit of, they slow down to hit the speed hump, they go over, and then they pick right back up. But that's useful information, so credit just to see.
Very well done. Thank you. Thank you very much. All right, our next workshop this evening, discussion and overview regarding one of our favorite subjects, bandit signs. Mr. Waite?
Good evening.
And in fact, I think that right now, not having had the second reading, that garage sale signs that don't conform to our old ordinance are still bandits, aren't they?
I would assume so, yes.
Yeah, I think so. But that's probably not directly related to what you're going to talk to us about.
Well, a little bit. So there have been some comments made recently about bandit signs and how do we get those taken down and what can we do better about that. And so bringing forward tonight a little bit about what they are, and what we're currently doing, and then what our plans are to start doing after the first of the year. So technically, in our ordinances, a bandit sign is defined as any temporary ground sign announcing a subdivision, new development, or builder. But the term bandit sign that we all use is really for any sign placed in the public right-of-way that doesn't have permission to be there. And right now, under our ordinances, that's any sign in the public right-of-way. And so our UDC speaks of that as in its sign ordinance sections. And it basically says any illegal temporary sign shall be removed immediately by, quote unquote, city personnel and disposed of immediately. And so the question had come up, I believe, at last week's meeting about what exactly is city personnel and who it is that can do that. And so we'll touch on that a little bit here in a few minutes. Currently, right now, it's our code enforcement guys that are doing the majority of this work. Our building inspectors in the development office also do some of this when they're out going from building site to building site, and if they see an inappropriate sign in the right-of-way, they'll confiscate those as well. And we're doing that work pretty much Monday through Friday, maybe occasionally on the weekend if one of them is out and about, or if they have some special project on the weekend they're working on. But for the most part, they're here Monday through Friday, and we don't have coverage on the weekends. Some of the things we know about these bandit signs is that there's actually professional companies out there that put these things up. So if you happen to be out trolling around some of our right-of-way areas at 2 or 3 o'clock in the morning, you're likely to see some folks out there putting these bandit signs up on Friday night going into Saturday morning. The other thing that we've noticed is that we don't have we have some really intelligent folks. They can learn the patterns, and we have actual businesses here in Schertz that after 5 o'clock on a Friday will go out and put their bandit signs up in the right-of-way in hopes of getting the most bang they can throughout the weekend with those before code enforcement comes back in on Monday. Our code enforcement guys go out there and they attempt to follow the TxDOT standards in that they document all the signs that they take. They shoot a picture of it. They document on a report where it was exactly. They attach that picture to it so that if anybody comes in and complains, hey, that was my private property, that wasn't the right-of-way, or you shouldn't have taken my sign down, it was on private property, then we have the picture to be able to show them that it was actually in the right-of-way. We also know that we have several private citizens and maybe at least one elected official that is occasionally taking down bandit signs. A lot of homeowners associations do this within their HOAs. They'll go throughout their neighborhoods on their streets and pull down these signs on the weekend. And some of those are garage sale signs that don't meet our current ordinance before we had started those discussions. Other signs that may come up within the neighborhood about a ball league or a youth sports association or whatever, and they pull those things down because in their HOA they don't want those things sticking around in their public spaces where their entryways are and things like that. And then the other thing we do to kind of abide by the tech stop piece, and in case anybody wants their signs back, is that we don't dispose of them for about 10 days after we collect them. And then we put them in the dumpster. We do repurpose some of their equipment that we confiscate if they don't come get it for different things that the city needs throughout the year as well. So that is kind of where we are today. And when we talked about bringing code enforcement and the marshals into the police department, one of the things that I told you I thought that we would see out of that is some greater efficiency and some ways to work smarter. Our police chief has a passion about bandit signs. One of the things that is a passion for him is that it's the folks who put their signs out knowing that it's against the law, and they're specifically waiting until code enforcement is not out and about to do it. But anyway, he has, and he lives in our community, he loves our community, and he has a passion to help make sure that it looks beautiful at all times. So one of the things that we're going to start doing is a few things. One is you authorized in the budget process a new code enforcement officer. We're beginning the process of hiring that position right now. That new code enforcement position will be assigned duty time on Saturdays to go out and specifically for this, but also some other code enforcement complaints that we think we might be able to more effectively reach on weekends, especially with tall grass and weeds and things like that, that it's difficult to find those people at home during the week because they're working. Hopefully we can catch them at home on the weekend. But the other thing code enforcement's going to do, and they're planning this right now, is that they're going to provide training to all of our patrol officers. So that on the weekends, either while on duty or maybe even spending a little bit of overtime when we see busier times of these bandit signs popping up, is that our patrol officers will also be able to stop and take those signs. Being law enforcement officers, they'll have access to be able to track those the same way code enforcement does, take a picture, write a report, and then be back on their patrol. So that'll get us more eyes on it. The other thing that we're hoping that we'll also do once we provide that training to our officers is that potentially we'll be able to catch the folks that are putting the signs out at 2 and 3 in the morning while they're actually putting them out. And maybe offer some citations to those folks and let them know that those services really aren't welcome here in the city of Schertz in our right-of-way. So that's another thing that we're hoping to get out of that. The other piece that is critical is that as we move this forward, this has been the way that we've operated, and it will continue to be the way that we operate, and that is that all signs in the public right-of-way are going to be removed, regardless of who they belong to. And when we get to the end on the question slide, you're going to see the back of a code enforcement truck with a bunch of signs in it, and you're going to recognize some of those signs from what we would consider legitimate businesses here in the city. However, they're putting their signs in the right-of-way, and we can't discriminate. We can't say this business is okay to do it, but this one isn't. So all of them have to come out of the public right-of-way. And that's important because we have some folks that get upset with that. Whether that's advertising a new grocery pickup, whether that's advertising an open house, whatever that is, those signs in the right-of-way, when code enforcement goes out, they don't discriminate. They all come up. The other thing we're looking at long-term is potentially expanding this training to our public works crews. They understand very well how to operate safely in the right-of-way. They're out in the right-of-ways a lot of times doing work, and if those signs are there, there's no reason to call code enforcement out and duplicate services. We can increase that efficiency by having public works take them, shoot the picture, write up the report, and file it, and have those signs picked up in a little bit more efficient manner. The other thing we will continue to do, however, is to discourage folks outside of code enforcement and law enforcement and potentially public works when we get them trained from gathering up these signs on their own due to safety issues. Primarily where we see a lot of these bandit signs are in the right-of-way along major thoroughfares. Without lighting on your vehicle, without a safety vest, being out there working next to the roadway is extremely hazardous. I can't stress that enough. We don't allow any of our public safety personnel to be on a road, work in a traffic accident without safety vests that meets federal criteria for visibility, without having emergency lights activated. And so from a pure safety standpoint, standing on the side of 3009 or standing on the access road to 35 trying to get those things out, nobody ever thinks that anything bad's going to happen, but bad things happen all the time. So from a safety standpoint, we discourage that from folks that aren't in marked vehicles with emergency lighting on them to help warn traffic that there's a vehicle sitting there. And then the other one, besides traffic lighting and visibility, is that there can be sometimes where private property issues come into play. And although we're confident we're on the right-of-way, we may not be on the right-of-way, and we may actually be on somebody's private property taking a sign. Now, if that sign's permissible or not, we're not going to get into that. That's something we'll handle Monday through Friday with the private property and the sign owner and the business owner that sign relates to. Because it may be a non-conforming sign, and we do need to do something about it. But we're not going to be doing that on the weekends as best we can when we're out confiscating the bandit signs off the right-of-way. We'll deal with that. We'll talk to the business owner. We'll help educate them as to what those things are, if they believe they're on private property or if they actually are on private property. And then the other one may be somebody may get really upset if we're out there removing their sign, even if it is on the right-of-way. And so that could also be a safety issue. Somebody gets mad because, they've spent good money in having those signs put out there by those folks at 3 in the morning. So I learned something in preparing for this, by the way. Some of the signs you see that look like they've been done by magic marker have been printed by a professional printer to look like they've been done with magic marker so that folks will believe that they don't have as much overhead and maybe they'll get a better price for calling them for their services. So very interesting fact that we've seen in some of our signs that we've taken. So that's really it on the bandit sign perspective, kind of where we are today. You're right, we're not doing much on the weekends, but we do have a plan to start addressing this after the first of the year. I believe the chief and our code enforcement guys are working on training for January so the patrol officers will be thoroughly equipped to be able to go out and make these good decisions and confiscate these signs. And when we get that new code enforcement officer up and running, they'll be out there as well. So any questions?
Council, questions for Mr. Waite? Mr. Edwards?
Of course, I have questions about this. Number one, I want to know if council would be okay with me passing an emergency budget amendment to get the mayor and myself 2 yellow vests, safety vests. No? Okay, that's a joke. Number two, really. So I see these signs here, and they have phone numbers and everything on them. Are we going to educate these stakeholders or these business owners or these organizations? This is what's going on, and this is the reason why. It is absolutely, it could be considered an eyesore, but it also could be a safety issue as well. If people are distracted, so we talk about distracted driving, if people are distracted by looking at a bandit sign, it could also cause an accident.
Our code enforcement officers today are working with our local businesses that are putting them in the right-of-way to help educate them about why we don't want them in the right-of-way and better ways to advertise their services than doing that. We don't get too involved. It's hard to see, but way up here in the front of the truck is a cheap house for sale with a phone number on it. We're not getting too involved calling those folks. But we are dealing with our local businesses. You can kind of recognize some of the signs here and that one there, maybe if you squint and see that. But the folks that we know are local that are trying to do the right thing, trying to get their message out, we go and meet with them. We take their signs, but then we go and meet with them about what's a better way to do this, what's the sign ordinance really say, what's the appropriate way to advertise, and get them involved doing it correctly. So we concentrate our efforts on the folks that we know are here in town, our businesses here in town.
Just to echo what Mr. Greenwald said earlier about the signs, I think this is just the tip of the iceberg. We need to be diligent on this now before we go forward. So I think that's a great idea. Let's just start collecting signs. And it beautifies our community, keeps our community a beautiful place to live.
Absolutely.
So thank you.
I just comment. I try calling a number of these phone numbers. It's kind of a little sport of mine, and a lot of them actually just don't go anywhere. You can leave a voicemail, or it'll instruct you to send a text message only, or all kinds of interesting things. So it's I don't know. It's kind of sporting to test them out, but. I guess I probably shouldn't do that either, should I, Mr. Waite? Call people up and tell them to get their signs the hell.
That's your own personal business there, sir.
Yes, okay. All right. Anyone else questions for Mr. Waite? Dr. Scagliola?
I was wondering, do we still have a Citizens on Patrol program in the city?
We do. We still have a few folks that volunteer for that.
And are they going to be on the list for training also?
We train them up. If we can get them out there and do that, then yes, they would be included in that.
Awesome. Thank you.
So would that mean that if Mr. Edwards and I were to go through that program, we might get to play along?
I think if the mayor and Mayor Pro Tem, and I saw a thumbs up down here from Councilmember Place One Davis, I think
already
if
a
you
member.
guys wanted to become citizens on patrol, I think the police chief would enjoy that immensely.
Okay, well then we'll approach the police chief outside the meeting here and find out what's required to participate. Anybody else?
Is there a motion to be made?
Well, it's just discussion and overview. It's not on for action. So, but however, the sooner we wrap up, the sooner we can go talk to the chief. All right, thank you, Mr. Wade. I appreciate it. All right, the next item that we have, since we already went to the hearing of residents or the consent agenda items, I'm going to go ahead and read all these first. I suspect we'll have it number 2 pulled. But let me read these off, if I may. Item number 1, the minutes, and it's approval of the minutes of the special meeting of December 1, 2017, and the regular meetings of December 5, 2017, and December 12, 2017. Item number 2, ordinance 17L51, an ordinance of the City Council, an ordinance of the City of Schertz, Texas, amending the Code of Ordinances of the City of Schertz, Texas, Chapter 50, Miscellaneous Offenses and Provisions, Article 7, Garage Sales, establishing a penalty, repealing all ordinances or parts of ordinances in conflict with this ordinance, providing a severability clause, and providing an effective date. And item number 3, Ordinance 17K49, an ordinance of the City Council of the City of Schertz, Texas, closing and abandoning to the abutting property owners a portion of right-of-way between Savannah Drive and Lot 28, Block 2 of Savannah Bluff, Unit 1 subdivision, and establishing an effective date hereof. Are there any items that are on consent that should be removed, or items that are not on consent that should be included in the consent?
Mr. Mayor, I'd like to make a
Mr.
motion.
Edwards?
I'd like to make a motion that we remove item 2 for further consideration and add item 5 to consent.
Second.
I have a motion to pull item number 2 for individual consideration and add item number 5 to the consent agenda. I have a motion from Mr. Edwards, a second from Mr. Crawford. Mr. Larson, you...
Mr. Mayor, I'd like to make an amendment to that motion, and I don't want to get it too confusing, but I want to add that we would also pull number 1 minutes simply for a simple correction on the vote tally, and also add number 8 to the consent agenda items.
I have an amendment to the original motion to pull item number 1 from consent and add number 8 to consent. Is there a second for the Mr. Larson's motion?
Second.
Second for Mr. Davis. The first thing it will do is dispose of the amendment and see if that passes. Any other comments, questions from council on the amendment? If not, I'll call for a vote.
Aye.
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 7 ayes and no nays. Therefore, we will take up the motion as amended. The motion as amended is to pull item number 2, add number 5, pull item number 1, add number 8 to the consent. Any other comments or questions from council? Hearing none, I'll call for a vote.
Mayor, let's go ahead and read 5 and 8 so that we've read the captions.
Okay. So our city attorney brings up a proper point of procedure. This point is well taken. Item number 5, Resolution 17R123, a resolution by the City Council of the City of Schertz, Texas, appointing Ken Greenwald to the Board of Directors, Place D4 of the Schertz Seguin Local Government Corporation, other matters in connection therewith. Item number 8, Resolution 17R124, a resolution by the City Council of the City of Schertz, Texas, authorizing a revised City of Schertz investment policy and strategy. Any other comments or questions from council? I'll call for a vote.
Aye.
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 Aye. Aye.
Aye.
7 ayes and no nays. The items number 3, number 5, and number 8 pass on consent. So given that 3, 5, and 8 have passed, we'll now go back to item number 1, the minutes. And Mr. Larson, I think you said that you had a minor correction to the minutes?
Yeah, just in the December 12th minutes on the discussion item regarding placing an item on an agenda for discussing social media policy, maybe it's kind of confusing, but the amendment, the vote count on the amendment to Dr. Scagliola's original motion shows Mr. Edwards as a yes, but he should be a no, and then it shows me as a no, and I should be a yes. Does that make sense to anybody?
Anyone disagree? I think that was in fact the case. The amendment, a motion to amend was made. There were 5 nays and 2 ayes by my recollection. Those 2 ayes being Mr. Gutierrez and Mr. Larson, the 5 nays being Mr. Davis, Mr. Edwards, Dr. Scagliola, Dr. Kaiser, and Mr. Crawford. Those 5 and then 2, if I'm correct.
I believe Mr. Davis voted yes for the amendment, but then he also voted yes on the final.
Is that correct, Mr. Davis?
You know what? I don't know off the top of my head, especially considering we had some changes to the motions. I would recommend, or I would ask that we just go back and have the city secretary relook at the tape and make sure that the appropriate votes are recorded.
In that case, I'd entertain a motion to approve the minutes of December 1, 2017 and the regular meeting minutes of December 5, 2017.
So moved.
Second.
A motion from Mr. Davis, a second from Mr. Edwards. Any other comments or questions from council? Hearing none, I'll call for a vote.
Aye.
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 7 ayes and no nays. The motion carries, passing, or rather approving the minutes of December 1, 2017 and December 5, 2017, taking no action on December 12, 2017, and we'll have that brought back before us at a future meeting. The next item on the agenda is item number 2, Ordinance 17L51. I've already read the caption. This has to do with garage sales. Council, I'll start out with Mr. Edwards. Questions, comments on this one?
The only reason I wanted to pull this item, I got to be candid with you. I said last week that this was going to potentially be a problem. Mr. Greenwald came up and spoke earlier today about signs that were found down in the Schertz Park. That could just be optics of what people see or being driven around, but we may want to consider if we're doing the right thing with this particular amendment.
Yes, sir.
I think,
Dr. Scagliola, certainly.
Yeah, I tend to agree with Councilmember Edwards. I think if you get the impression that there are no fees associated with garage sales, there are people going to start assuming that there are no requirements associated with the garage sales also. We still have the requirements on the book that certain procedures must be followed, and until that gets until we get that message out there, I think some people may be under erroneous conclusions or assumptions. So I would recommend that we actually get the word out. Use all the means available, Schertz Tales, whatever other media outlets we have to actually get the word out and let them. Hey, this isn't going to be a free for all. We're not turning the city of Schertz into an extension of Bussies. I'm all for the intent of this. I just want to make sure we're well educated before we jump into it, and also like to have an update in about 6 months to actually see whether or not the policies or practices are working.
Others?
Mr. Mayor?
Mr. Davis?
I'm going to have to disagree with my colleagues at the far end of the bench. Driving around the city, I noticed plenty of garage sale signs, estate sale signs, and every other kind of sign back when we had permits or a requirement to have permits. And then throw on top of that the permit signs that we would issue to somebody when they were having a garage sale. We discussed the permit requirement, and to me, the value is the reduced workload on the staff to even go through this entire process. You're right, there's an education piece of this. I mentioned that when this first came up, that we've got to get it out in our magazine, we've got to get it out in the local newspapers, we got to get it out to all the HOAs. But I think the biggest issue is and I think the city staff did a great job of giving us a way forward tonight on bandit signs in general. Driving around the city, it's just not a garage sale sign. Driving around this past weekend, you saw what's in the back of that truck. They're everywhere in the city, and I think the right thing to do is let's take a burden away from our staff. Let's take a burden away from our residents, and let's see how the new process goes with getting more folks out there picking up these signs on the weekends and resolving the issue that's the problem.
Hey, Mr. Crawford?
I'll speak to Mr. James and the council and the audience I like what Mr. Scaglione said. I like what Mr. Davis said. People got in a hurry and started doing something they might not should have been doing as far as putting signs out that don't conform to our standards. We've talked a lot. You have a department that does planning and zoning. That also gets involved with inspections. We try to have a city that looks nice. But as Mr. Davis said, we see lots of signs. I see them driving around. So I don't know how to balance the aestheticness of having signs versus the fact that we would like to reduce staff workload. But tonight we're talking about adding another person to do bandit sign control. So I'm not sure where, I hate to say not approve it tonight or not approve it in a week or something, but I hate to say let's wait 6 months before we have any kind of resolution either. So I will leave it up to, we can make a motion to do whatever we want to do, but I just want people to speak. I'll turn it over to Mr. Larson.
Mr. Larson.
I think I'm excited by the presentation that talks about ways that we're looking to tackle bandit signs. I think it's certainly anecdotal, and I don't have any data to this, but I tend to see a lot more bandit signs than illegal garage sale signs, although I've seen both. I do want to make a clarifying point, though. Correct me if I'm wrong, Mr. James, but as of today, the rule is still that I would need to pay for a permit and use the city signs.
Yes, sir.
So any violation of our garage sale ordinance has had nothing to do with a change in the ordinance, because the current ordinance of requiring a permit to be paid for and get signs from the city still exists. So I don't think that the two are necessarily related. Any anecdotal evidence of additional garage sale signs wouldn't be related to the deregulation of personal sales. So I think we have, and my understanding also is that the new ordinance still places pretty specific limits on placement of garage sale signs, size of garage sale signs that are very much in alignment with what we currently have today. Is that correct?
Yes, sir.
So with that in mind, I don't see any reason not to move forward. Really, the idea of eliminating the permit fee is, one, why should you have to pay the city to sell your stuff? But two, it's just a burden on the city that really the people who are going to follow are going to follow people that aren't. The enforcement has been lax. We have a pathway forward in terms of the bandit sign portion of the enforcement that seems pretty clear and promising. And so I think certainly I don't want to make a motion premature, as I know other people want to speak, but I think it makes sense to move forward and just simplify our ordinances for both the purpose of city staff time and citizen.
Very good. Mr. Gutierrez?
Mr. James, is there a cutoff right now where, they have to get the permit so they can have a garage sale?
The cutoff would be if it's approved and the mayor signs the ordinance, then the next day don't have to get a permit.
The current procedure. How about the current procedure is what I'm referring to.
So
if I want to have a garage sale this Saturday,
yes, sir.
Can I still pay for it on Friday and still have it?
You can under the current ordinance, yes, sir.
So what we're trying to do is eliminate the administrative burden that we have on our staff. Right now citizens still have to come in, residents still have to come in and purchase their garage sale. Why not have a book and have them sign up saying, I'm having one this weekend? Mm-hmm. There's no need to purchase any signs. If we pass the ordinance, they simply sign in saying, I'm having one. And it eliminates the administrative burden. It's just a public notice that this residence had one this past weekend or
yes, sir.
This weekend coming up.
So my initial reaction, and certainly if council says, hey, staff, why don't you go back and chew on this and think about it, that's one thing we will do. And I will say this maybe as a just to open up, based on the conversation council has had, which in the past, which is let's look at what's most important to us as a community, where staff time is best used, and what are those things that add the most value to the community or frustrate our residents. We've started looking at things like this, and the idea is let's take a look at it, come up with just one of probably many options and bring them to council. And likely we'll do that going forward with other things, and some you'll say, yeah, let's make that change, others let's not, others maybe do something different. So one of the things that is a bit of a concern with this is, the concern is if we don't require a permit and or if that permit doesn't have a fee with it, even fairly nominal, that folks tend to think it's unimportant and then they tend not to do it. And so the problem would be if we have a requirement that folks need to come in and say, I'm going to have a garage sale, they may think, well, they don't require a permit. I don't know what the city does with it, so they just don't do that. And then when there's a problem, we say, well, you violated the ordinance, potentially you've not done that. And so we can certainly look at that, but I think typically that's where staff tends to go. If we want to require someone to come in and notify us, our means is to require a permit, however simple that form may be, and it can be very simple, name, address, whatnot, times you're doing it. But then if we don't require a fee, even fairly nominal, folks tend not to do it. Again, to be clear with this, what we tried to do is keep what you would see out there the same with this change. So again, as was asked by council members, we still regulate it. So you still only get the 2 signs you can place. They're just not yellow, but the size is restricted to about what we've got. Still can't put them in the right-of-way, which is typically where we see bandit signs. If you want to put them down at the corner, along a collector that's within your neighborhood, you need to get your neighbor's permission to do that. Otherwise, your neighbor can call and say, hey, take it out. And then with regard to enforcement to the number, really what it would be, it slows that down a little bit, because typically what we would expect is a neighbor saying, hey, I guys had like 4 or 5. Call the city up. The city then would start tracking when they're having it. We'd rely on the person to call and go, yeah, they're having this weekend. We go out, we document, go out and document, go out and document. At that point, we say, you've had your 4. If you have another one, you're in violation because I can document your 4. So that's what we were trying to do. But again, we can certainly chew on that, think about it, maybe talk to some other cities. But that's my initial reaction is if we don't require a permit, it's hard to get people to come in and do it. But we can look at it.
Thank you. Mr. Edwards.
So are we shifting the burden of man hours, so to speak, over to the bandit sign enforcement? Because you said we're alleviating man hours or staff constraints and time, but we're putting that on to the bandit sign. So does that make sense?
No, that makes perfect sense. So, and I will say this: we have numerous sign issues, and so despite what our ordinance says, let me kind of define a bandit sign this way for the purpose of this conversation. A bandit sign is a sign that's placed in the right-of-way. So it's something where they put it in the parkway of the road or the median of the road. We don't allow any of that. So again, even if you're a business with a CO, you can have a sign, you got to keep it on your own property. And so to me, this doesn't change any of that at all, because if it's in the right-of-way, it shouldn't be there. Even if it's one of our yellow, we get it, pull it out, can't be there. So to that degree, it doesn't. I will say is, if it's on private property, if it's within the neighborhood, knowing that we issue only 2, it's maybe a little quicker to say, hey, it's a yellow city one, so it's okay, versus, hey, there's one for this address at 300 Elm Street. If there's another one, 300 Elm Street, there's another 300 Elm Street. That tends to be not as much the problem we have. What people tend to get frustrated about is you're driving up and down Schertz Parkway, the frontage road of 35, 3009, and you've got stuff up and down in the right-of-way. So I'm not trying to minimize that there are these issues, but for that primary problem, it doesn't, in my opinion, alter the issue at all. I think what you've heard, and our folks would tell you is, yeah, they wait till we're off work at 5 and they go stick them up, and really the issue is how we tackle that as a team. And again, hopefully, and I will say, every community I've worked in, bandit signs is an issue, and it's a frustration, and you'd be amazed at their persistence. But again, the solution, as we've talked about, is us to be persistent to deal with it.
All right, Mr. Crawford.
Mr. James?
Yes, sir.
We've talked about, like, I'm going to call it the bandit sign patrol, and not trying to be funny.
Yes, sir.
How long, what's your estimate on when that might be available? Because that's, from what I believe you've said, that's the biggest problem, and I think that's the problem Mr. Greenwald was addressing when he came and spoke at hearing of the residents, that we're getting signs put up that aren't in the right place or shouldn't be there, even if they are in the right place. They don't conform to our standards. We're keeping our standards. The thing we're not doing is we're not going to charge a fee anymore. Is that correct?
That's correct. We don't charge a fee, and there isn't a permit required.
And the information got out, and it's news people wanted to hear, so they just overreacted. That's kind of what I think you're saying. So my comment would be make a motion that we adopt this, and we come with the it's not really a contingency. We've talked about the bandit sign patrol as a favorable thing, if that's what council believes. So we have a mechanism to deal with the issue of bandit signs a little bit more effectively. And we adopt the resolution as it is now, and just put a comment on there that let's come back and have a report from you on the first council meeting in April, and anyone else that wants to speak at hearing of the residents, and we can all look ourselves and see what we think about what it looks like. If it turns out that we've got a flower garden of bandit signs, maybe we need to go back and have a fee. I don't know, but my motion would be accept what we have tonight with a review of what kind of complaints we've had on the first council meeting in April. That gives us 3 months, and have a feel if we made the right choice. It's not a big deal. We can go back and change it if we don't like it, or make another recommendation.
I'll second that.
So, Mr. Crawford, based on what I hear you say, that you're making a motion to approve 17L51. That's
Yes, sir.
correct. Okay, I have
With
a
the
second
only-
from Dr. Scagliola. Other comments, questions from council?
Mr. Mayor, I think there's an amendment to it as well.
Okay. Mr. Crawford?
The motion was to do what you said and have a feedback from staff how things are working on the first meeting in April.
Very good.
If we got a lot of comments that, hey, this isn't working at all, we've got to look at that again. If it's manageable, that was my motion.
Very good. So just to repeat
Thank
it
you.
back so that it's clear, the motion from Mr. Crawford is to approve 17L51 and requesting that staff come back before this council the first week of April to give us a report on what's going on since this ordinance was passed. I have a second from Dr. Scagliola. Mr. Gutierrez, you had something?
Yes,
you'd like
yes,
to say?
sir. Is your motion to go ahead and eliminate this ordinance so that later on in April we have to reestablish it again?
No.
No, it's a motion to approve on final reading.
Thank you. Thanks for clarification.
Bet anyone else? Dr. Kaiser?
I guess I have a question on, I know you want to be able to get comments and things like that. I want to make sure that, because I really don't have a problem approving it, but I don't want to come back in April and just hear some stories about, so I want a process as to how you're going to determine if we now have this huge problem that we didn't have prior to the ordinance. See what I mean?
Yeah, no, I know exactly what you mean, as opposed to anecdotal evidence of kind of here's what we're seeing and what we're doing. I think the challenge, so what we can do is we can certainly quantify the number of complaints we get from citizens saying, my neighbor's having a garage sale that's out of compliance with the ordinance. We can document and quantify that. We can certainly try to, with pretty good accuracy, quantify and documenting how many garage sale or estate sale, I'd call it the same things, we pick up. I don't really have a point of reference, but it'll give us something there to go by, and then certainly we can ask or maybe document a reaction we get from citizens who come in or call up and say, hey, I'm here to get a permit, and we can say the ordinance has been changed, you're not required to do a permit, you can do your own stuff. We'll have the handout, and we can try to document a little more qualitatively what their reaction is. If it's, wow, that's great, I've really always wanted this to happen, or, yeah, this wasn't a big deal, why'd y'all make the change kind of thing. So we can quantify a couple and qualitatively do another.
Mr. Crawford? Okay. I'll just make a comment. I do think that communication to the residents is a good idea. If we can do that in the magazine is probably the most significantly read publication of the city, be it online or otherwise. I'm hesitant, of course, now to post something on my personal Facebook site about it. But I may do it anyway. But I do think communication of what we've done, what our expectations are, is very important and an integral part of this being successful. I also think, to Dr. Kaiser's point, that everyone on this council will be watching carefully, seeing what's going on, hearing from our neighbors, seeing what we see as we're driving around the neighborhoods, and we'll have feedback in addition to what we get from staff. So I think that'll also be valuable. That said, I do have a motion, properly made motion, and a second. Any other comments or questions from council? Hearing none, I'll call for a vote.
Aye.
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 All right, I have 7 ayes and no nays. The motion carries. That takes care of item number 2. Item number 3 was passed on consent. Next up, then, is item number 4, Resolution 17R121, a resolution by the City Council of the City of Schertz, Texas, authorizing the city manager to enter into an agreement with Physio Control Incorporated for the purchase of 10 chest compression systems and add service agreements on all devices. Mr. Mabbitt, good evening, sir.
Mr. Mayor and Council, we're looking for approval into that agreement with Physio Control for the lease purchase of 10 chest compression systems. The current ones we have are 7 years old. As part of our replacement plan, we were looking at purchasing 2 every year just to swap them out. Unfortunately, they don't make the ones we have anymore, and they made us a pretty good deal to swap all of them out at once.
Then these are the ones that you've shown us before that maintain a constant compression rate and don't tire like human beings do.
Absolutely.
Right?
Yeah, it's piston-driven chest compression devices. Yes, sir.
Very good. Questions for Mr. Mabbitt? Mr. Davis.
Mr. Mayor, I sat through too many council meetings out there where they brought in people that were saved by our city staff, and I know how important this equipment is to them. I'd make a motion to approve 17R121.
Second.
I have a motion from Mr. Davis, and my right ear caught a second from Mr. Gutierrez. However, was there a question or comment from council, Mr. Crawford?
I have no desire to not approve what we're doing, but I have a question. In your document, you said you had planned originally to do 2 a year to get them all replaced.
Yes, sir.
What's the replacement option if you buy all 10 of them at one time? Does the maintenance contract we have with them make them stay in good enough shape and current enough to be used more than 10 years so we can get back on some kind of a policy, or do you want to decide to change them out every 10 years or whatever the right number is?
No, so last year was the first year we put the current ones on a service plan. Now we're starting it from the start.
From day
so
one.
We do think we'll get more use out of them. Yes, sir.
Okay. So we'll just wait and see how things play out.
Yes, sir.
Okay, thank you.
Anyone else? Comments, questions? Do a properly made motion from council. I'll call for a vote.
Aye.
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 7 ayes, no nays. The motion carries. Thank you, Mr. Mabbitt. Item number 5 has already been disposed of under consent. We now move to item number 6, Resolution 17R125, a resolution by the City Council of the City of Schertz, Texas, authorizing contracts with VIP Staffing, LK Jordan and Associates, and Apple One, each totaling no more than $50,000 or $75,000 cumulatively per fiscal year for temporary staffing services and other matters in connection therewith.
Thank you, sir. Good evening. Council, as you know, the city sometimes has a need to employ temporary or contract staff, either to meet a planned need, such as somebody going out on vacation, or sometimes just to interimly fill a position until it can be permanently hired for. We also sometimes have unforeseen needs, such as folks going out on extended medical leave, things of that nature. So in both of these instances, we would call upon the use of temporary or contract staffing. And so to that end, we issued a request for proposals. We received a great response. We received 15. So we convened a panel of some representatives from HR, as well as some of the stakeholder departments, those using these types of contracts the most. We scored the proposals based on experience, qualifications, references, costs, and a couple of other items. So what you have before you tonight, we're requesting authorization to enter into contracts with the top 3 scoring firms. And as the mayor mentioned, those are Apple One, LK Jordan, and VIP. So the contracts would be for an initial term of 3 years with 2 additional 1-year renewal options, and that can be done by mutual consent of both parties. Each contract includes a not-to-exceed limit of $49,999 in cumulative spending during any one fiscal year covered by the agreement. And as the Mayor said, as part of the resolution before you, we've also included a not-to-exceed amount of $75,000 cumulatively between any or all of the 3 contracts in one fiscal year. We're not requesting any additional funds for these services or anything above what was approved in the budget. Any request from a department, the funding would come from that department and it would be realized through salary savings, cost savings, cost savings. HR will administer these contracts. One of the things that we've realized, and certainly in a contract like this where we have multiple departments using it, we want to make sure that there's a centralized process in place, a mechanism to ensure continuous monitoring of the contract and contract expenditures. So we have implemented a process to ensure this. I've met with finance. We have discussed how this process is going to play out. We have implemented some forms and some other procedures that's, again, going to help us ensure that we're not overspending contracts and that we're always compliant with the contract. So with that, I can answer any questions that you may have.
Cool. I have a question for you first this time. What you've described is normal and customary within the confines of this fiscal year because we've already allocated funds, but the contract period extends beyond this fiscal year. What would be the resolution if funds were not allocated in a future year, or what are our plans for allocating those funds in future years within the confines of the contract period being longer than the fiscal periods?
Sure. So the service agreements themselves are standard templates that were approved by legal. They do include non-appropriation clauses so that in any future years, should budget or should council not appropriate or authorize any funds, then the contract would become void. We would not be allowed to use it.
Perfect. Exactly what I was looking to hear. All right. Council, questions? This side. Mr. Edwards.
So you have $50,000. So how does this pertain to, we've already given the city manager an opportunity to not exceed $50,000 on any contracts at one time. So we're using $49,999 for 3 opportunities here, right? 3 different contractors.
That's correct.
But not to exceed $75,000 cumulative.
Cumulatively between any of the 3, yes, sir.
Okay, so how does that relate? And maybe Mr. Kessel wants to jump in here. How does that relate, Mr. Kessel? Because if we're talking about spending $75,000, we're going over by $25,000 if we do that.
That's what you would be authorizing with this resolution, is that spending capacity up to 75 for a cumulative total.
Okay, so you mentioned that you have several things that you're going to incorporate to make sure that we don't go over some of the criteria. Can you explain those?
Absolutely. So the process that we have developed, first of all, requires that the requesting department must complete a form, has all of the pertinent information, certainly the position that they're looking to fill, skills that would be needed, days and times, those types of things, as well as an anticipated term that the department thinks that they'll need this individual. So that will come to HR. We'll review it first, and it will be passed along to an executive director. So all requests for temporary staffing will be approved by the executive. So once the request has been approved, HR will coordinate to get the employees on campus. Once that happens, as I mentioned, HR is going to be the centralized body who is receiving the invoices, paying the bills, and monitoring all of the expenditures. So by contract, we will be monitoring, and actually even furthermore by department, how much is spent on a weekly basis.
And finance won't have anything to do with it?
I'm sorry?
Finance won't be monitoring this as well?
Well, as they do all expenses, they would be this one as well. Like I said, James and I actually met to discuss how we would be monitoring these invoices and how we would be paying them. So, of course, they would be involved in that.
The reason why I asked, we've gone over in the past.
That's correct.
And we've gone over several times in the past.
Yes.
Okay, so a double safety net to make sure that we're not crossing swords would be even better for you guys.
And actually, I guess to your point, yes, sir, I agree. And we have also determined so the invoices will not only come to HR, who is responsible for paying them, they will also be going to accounts payable, to finance as well. So 2 separate bodies will be receiving weekly those invoices. That was something that James and I discussed.
Thank you.
Mr. Kessel?
Well, and I just wanted to mention, Mr. Edwards, that one of the other things we've implemented is an expiration date. So the department head says, I need a temp staff for 6 weeks so I can get this position filled. At the end of that 6 weeks, the temp staff goes away. If they need it longer, then then the executive director has to approve that extension. So that will also, so going into it, if we need a temp staff in EMS billing, because we've lost an employee there and we need a clerk in there to do data entry, then we'll have them for 6 weeks. We'll know what that expense is up front for those 6 weeks of time they're going to work. So we're going to know going into it, and then there's an expiration date of when that temp will no longer be available unless it gets reapproved through the executive director.
Thank you.
Kessel, you had something?
2 points. First, Mr. Walters now has a policy that he sends out any contract that gets over a certain amount, and he sends that to different department heads, and we review those on a monthly basis. It is a third way that wasn't discussed that we can keep an eye on these things. What it tells you when you get that report is one of these contracts is getting to be $25,000. Okay, I'm not too worried. Next month it's at $35,000. Now I'm starting to pay attention because it's growing $10,000 in 1 month, and you can see that there's some concern there. It gives you a clue, and that's going out as to the department heads. All the department heads are seeing that, and when you open the file, you see everything in there in the rank order by the amount that's been spent that month. And it's something that we've not done in the past. It's very helpful. It's a little bit different than the methods that have already been discussed. The other thing is that technically these don't need to come to council the way that this is written, because it's $49,999, missed a 9 on that, less than $50,000. What we want to avoid is getting right up on $50,000 and not bringing that in front of council, even though these things are funded out of approved budget items. From our perspective, one of the very important things about bringing these items forward is to have a transparency so that different groups who may be interested in bidding can see, here's what the winning bids are. There's an understanding in our community that we're going through an open process and a fair process. And so when we get really close like this, it's important that we do bring this forward so all can see those contracts.
And Mr. Kessel, if I may just add to that, we don't in any way anticipate spending up to $49,000 with each of these vendors in any 1 year. One of the reasons that we wanted to award 3 was just so that we had some options if one agency is not able to meet our need in a timely fashion or provide, a certain type of employee. This just gives us some options, and again, gives us a little bit of flexibility so that we don't have to keep coming back before y'all if we, are using one agency more.
Thank you.
Mr. Gutierrez?
No, I withdraw my comments. It's been answered. Thank you.
Very good. Anyone else? Mr. Crawford?
I talked to Mr. James today, and I think I understand kind of where this is going, in that we're trying to have money available to provide for services from people who can do something to help us out when we don't have somebody on staff that has the time or the ability. And that means somebody had to do this, if I understand Mr. James right, that money has to be in that department's budget to do this, or we have to move money to that department, which finance comes to us and asks us to do that occasionally. So the management is going to be keeping track of how much we spend on an item that needs to be filled, which wasn't necessarily accounted for up front. Every department doesn't have money budgeted for this. Is that correct?
If they don't have vacancies in the department, there
Yeah,
might not be
right.
salary savings, correct?
So they can ask, and and then it would come to us to move money or whatever, however that process works. So all I'm saying is I want to make sure I understood what Mr. James said today, and that y'all understand that this is a way to try to get people to help us get over a hump when something goes haywire.
Yes, sir. And one of the things I'll also mention is that on the request that is required by the departments that submitted initially, they are required to identify the source of funding. And certainly if at that time we realize that they don't have any funding in their department budget, then we would, of course, get with the executive directors and also finance so that they could find a solution.
Okay, thank you.
Very good. Anyone else? Mr. Larson?
Mr. Mayor, just as I review this, it looks like even if we had never seen this resolution or passed it, the authorization has already been given by council to the city to expend these funds because it's not to exceed $50,000 for each individual contract. And so, as Mr. Kessel said, this has been brought to council simply as a courtesy and for transparency. And since the authorization is technically already there, I make a motion to approve resolution number 17R125.
Second.
I have a motion from Mr. Larson. I have a second from Mr. Crawford. Other comments, questions from council? We'll now call for a vote.
Aye.
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 7 ayes and no nays. Motion carries. Thank you very much. Item number 7, Resolution 17R122, a resolution of the City Council of the City of Schertz, Texas, authorizing contracts with LPA Incorporated totaling no more than $86,000 for the design of the recreation center, restrooms, and crawl space and various separate and unrelated architecture and design services during the 2017-2018 fiscal year and other matters in connection therewith. Mr. Waite.
Good evening. Mayor, members of council, back in October, our Fleet and Facilities Department was notified of an issue with the tile work down at the Schertz Rec Center that the YMCA operates for us. In both the men's, in the men's room, underneath the sinks, there had been a couple of tiles that came loose off the wall. Our facility staff, who is greatly experienced with water leaks and mold and that type of thing, went down there, looked at the tile, pulled it off the wall where it was loose, and noticed a black substance behind it, and so they immediately sounded the red flag. You can see here, this is the sink structure in the men's locker room / restroom, and the white substance you see on the floor up against the corner between the wall and the floor is actually tile grout that has come out from in between the tiles, which allowed one of the tiles or two of the tiles to come loose. Once we looked behind there and we saw the mold issues, we put the locker rooms on lockdown. We had our environmental firm come out to test the air, and then we arranged for ServPro to come in and begin mold abatement in those rooms. We were fortunate the locker rooms did not have any airborne presence of mold, especially the dangerous black mold or the sticky botrytis. However, it was present on the drywall, the material behind the tiles, that was the dangerous black mold. So ServPro came in and like they do so well, and unfortunately have had to do for the city on a number of occasions recently, came in and abated that by sealing off the restrooms from the locker rooms so that the Y could have their lockers available and the toilets available, which was a key for them. And then we started the abatement process. And what they do is they start tearing into the wall where they see it, and they keep going until they don't see any more evidence of mold issues. So they started on the men's side, and they started a little bit on the women's side, and they did the most progression first on the women's side. And here you can see a shower stall where we've gone through and basically they pulled the tile off, found the drywall wet, which is a key part behind the tile was drywall, not any type of concrete board or anything else. And they continued following that throughout both sides of the restroom until they believed they had found the end of the water damage to the drywall. So this is the beginning of where we started on both sides, and then we progressed into what you see here. And a very interesting thing to note are these studs of these divider walls in the shower stalls, especially this one here. I've got another pretty good picture of it coming up right here. It's an aluminum metal stud that you can put your finger through because of the corrosion that has happened to it. What we believe has occurred at our YMCA, or at the rec center, is that we've had issues in the construction of the showers where the shower pans have leaked for a considerable amount of time. And so fortunately, or maybe unfortunately, I don't know which, we had really great tile work done. And so the tile work was able to keep the water behind the tile where it would penetrate, it would build up, it would get in I'm pointing to the screen like you can see that, it would build up in these floor joists here and then get to the drywall and climb the drywall up almost to the ceiling on a few of the divider walls, especially on the men's side. Until finally, after a number of years, it finally pushed enough grout out underneath the sink on the men's side and the women's side to start water coming out and pooling on the floor, which looked like people who maybe didn't want to shower but were just cleaning themselves up at the sink had spilled water on the floor. So potentially for a week or two before the Y staff noticed the tiles loose, we had that water underneath there. So we brought in some guys and we did some more demolition, and basically we've taken, if you've been to the Y lately, customers of the rec center, Y members can go in and use the toilets and one sink, and everything else is walled off, and that's because we've demolished everything else in those showers. The walls are out, the ceilings are down. You can pretty much go side to side in there, and so for security and everything else, those have been walled off, and the Y doesn't have access to showers in that rec center building. They do have showers in the aquatic center, which folks who come there and work out early in the morning or throughout the day can go over to the aquatic center and take their showers. But it's kind of important. We need to get these bathrooms fixed, and we need to get them fixed correctly. While investigating this problem, we also took some time to go down underneath the Y into the crawl space underneath, and we found a couple of other issues down there. We found a leak not associated with this, but a leak in the drain in a janitor closet that has since been repaired. And then we found some other issues with the Y in that crawl space that need to be corrected. Primarily, there's nothing covering the subsurface under there. You can see where, when it was originally built, we put some material down as if we were going to do all of the subsurface with that material. But instead of doing the entire coverage under there, we probably did 10% of it, and then the work stopped. And then the way the sump pump was installed, which if water gets in that crawl space, it drains to a tank, and then the sump pump pumps it out and gets rid of it. It looks like it was installed inappropriately, and so there's a separator there because the dirt's not covered, so the water would bring dirt into this tank, and the sump pump and then it would separate, the water would go over into another tank, and we'd pump it out. The pump is in the hole where the dirt and the water come in together, and so the sump pump is about 3/4 covered in caked on mud and dirt and stuff that needs to be repaired and fixed as well. Staff looking at this and talking with some folks have determined that it's pretty much going to be a complete refurbishment of both restrooms and locker rooms, the restroom facilities in the locker rooms. And staff's desire is to come back with a little bit more appropriate construction here. Instead of metal stud walls and drywall, is to come back potentially with CMU block, and then use commercial grade fixtures instead of residential grade fixtures. So the Y takes care of the maintenance. They let us know that they've been replacing the cylinders on their showers about twice a year because of the volume that they were put in there. And when the building was built, it was built with residential fixtures and not commercial fixtures. And so come back with that, and then rebuild the shower floors appropriately so that and put in appropriate shower pans so that we won't have this continued leaking process that evidently we've had for potentially 5 to 7 years behind that tile. Also, the other repair that we'd like to make is to look at our options for sealing the subsurface underneath in the crawl space, and then fixing the sump pump, so if we ever do get water underneath there, we have a bona fide method of getting it out from underneath there, and it doesn't become a public health hazard sitting under there and getting nasty with mosquitoes and mold and that kind of thing like that. So the city has worked with LPA architects on a number of projects. Most recently, they designed the refurbishment of the senior center and the waterproofing of the fire station 2. And because we have experience with them, because they're a known entity, we would like to ask them to do the design and architecture work necessary for refurbishing these restrooms. Since we're putting cinder block wall in the place of metal stud wall, there's going to be some engineering costs and things in there to make sure that those things are done appropriately. There's also we need to do some electrical redo if anybody's ever used the showers at the Y. The lights are not in the shower, they're in the hallway. So when you go in the shower and pull the curtain, you're pretty much in dark. You can't see what you're doing in the shower. So electrical needs to be redone to put lights in all the shower stalls, and we just need to deliver a better product there. LPA, we asked them, and they gave us a proposal to do the design features and to help manage the construction for, their quote was $47,560. Staff would like a 10% contingency on that, just in case. There's certain things we don't know yet because the complete demolition's not happened, and the architects haven't been in there with their engineers and their architects to determine how do we do block walls, how do we run this new plumbing, this new electricity. So there may be some things that we don't know quite yet. And so in November, we paid the last bill on Fire Station 2, and it was in this fiscal year, but that was for $17,950. The total not to exceed for the rec center refurbishment would be $52,316. And then we felt to put in a little additional funds so we don't have to come back to council if there's a small project or something else, maybe, anything you could think of, we might just need a quick down and dirty design for on a building. So we said $15,000. I rounded it up to $86,000. So that's why it's $15,734. There's no known entity there. I just rounded it up to 86, so it'd be a round number. So we're asking tonight for two things. One, to exceed the $50,000 spending limit with LPA for a total not to exceed for this fiscal year of $86,000. And secondly, the city secretary sent this out this afternoon. I recognized an error in my resolution with this, and so we added a section 2 where we're asking council to also authorize the fees to pay for the rec center design and architecture to come out of the 2016-2017 certificate of obligation funds. And again, that amount is $52,316. Then staff will come back once we have that design done, and we know what all it's going to take to do that. Then we'll have an estimated cost that is a cost that we feel is something that will be close to accurate when we go out for bid, and then we'll come back to council and discuss where those funds should come from and get authorization to spend those funds before we go out for bid for a person or a firm to do the construction work.
All right, so I'll start us off on this one. I guess the first lesson that we have here is that in a significant economic downturn, council probably shouldn't direct staff to act as general contractors when that's not core to our skill sets. So lesson learned, once again. Back when the city council took that action, it was right in the middle of the recession. We had a good idea that we could save a significant amount of money by taking on this work ourselves, and we've shown both in this building and in the fire station number 2 that didn't work out so well. So that's my first comment here. The second comment is we need to get this done, and I understand that you're recommending we use certificates of obligation for the $56,000, $52,000 and change. The remaining funds would come from where?
So once we know that number, we'll be better able to estimate.
I mean, the 15,000 that gets us up to the 86. Is that all from the COs?
Oh, that 15,000 will be based upon what we use that for. So that may be something that facilities uses it for to do a minor repair. That may come out of the facilities budget. So it's all going to be dependent upon what project that would be tied to, or why we would use that 15,000.
Okay. Council, questions for Mr. Waite?
Mayor.
Mr. Crawford.
Mr. Waite, help me out on something, please.
Okay.
In your agenda item number 7 on the second page, it starts off saying, to date, in this fiscal year, 2018, the city has spent $17,950 to wrap up the design services for Fire Station 2 and the Senior Citizen Center.
Yep.
That's money that's already been spent,
Mm-hmm.
and it was spent with LPA. No problem with that at all. The money is already allocated to those 2 projects, correct?
That's $17,950. Yes, it came out of the project fund y'all allocated last year for those.
My question is, why did we add that in to come up with the $86,000 when that's already been approved for and allocated? What we're trying to do now is come up with the money spent, or that's going to be spent, for the 47,560, plus the other 20,490, which is 68,050 or something like that. So why are we adding another 17,950 to be approved when that money's already been approved, allocated, and spent on another project? How come we're not
Because
just asking for just $68,000?
the policy we operate under is not spending any more than $50,000 worth of.
No, I understand that issue. I have no problem approving or recommending we approve or voting to approve that we spend over $50,000.
Yeah.
What I'm questioning is why is there an extra $17,950 that we're approving when that went to another project or two other projects that are already done, already paid for, already completed, and that money, just because it was allocated to the company, it's like a two-part question. One part is we're asking to approve up to $86,000 to be spent with LPA. That's not a problem. But the amount of money we're actually spending with them now, that it makes it sound like we're approving to spend that amount of money, is only $68,550.
That is true. That is the additional amount we're asking to spend. But the total for the fiscal year, we want to set a not to exceed of $86,000.
I just want to make it clear that part of that money is already allocated. We're not approving to spend $86,000.
No, sir.
We're approving
what you're
to spend,
approving is
to
to
approve the
spend
limit of up
up
to
to
86,000 for
$86,000 this
LPA,
fiscal year.
and we're only going to spend $68,050 on this project, unless you come back and ask for more.
That is correct.
And then the last thing you said at the end of the thing is we're going to use money from the previous fiscal year certificate of obligation on stuff set up for facilities. Is that correct?
So yes, sir. Those certificate of obligation bonds were sold. They've not all been
understand.
allocated out for what projects they're going to do yet, but they are all for facility repairs.
Okay. Thank you.
You bet.
Mr. Larson?
Just to clarify, this is only the cost to design the fix, not to enact the fix, correct?
That is correct.
And so
it's actually to carry us through the construction, so they'll help us with the bid process and reviewing the bids and watching it through construction, that they're building it to their design.
And I guess, because I guess as we're looking at what could potentially be a $500,000 plus project, which I think is something we absolutely need to do, but the question is, do we have any ideas of where the remediation funds will come from? And the only reason I ask that is I would hate to spend $50,000 to get a design and then be like, oh, well, we're up the creek without a paddle. We've got nothing to do with this design.
Well, part of the design is going to be what is that cost going to cost us? And so there's going to be meetings during that design phase as it progresses where we're sitting down with the architects and saying, okay, where are we going at with this? Where are we going? I said, well, we can do this CMU block and we can do all these really great fixtures and that's going to cost you $3.8 million. We're going to say, okay, whoa, wait a minute. What are our other options?
If they'll come back with $3.8 million, you'll make me
but
mad.
Right now, we we don't know what range that's going to be in because the architects haven't had a chance. I mean, we want to install CMU block in an area that was not originally designed for that. And they're single wing walls.
Mm-hmm.
So what engineering do we have to do to make sure once those are installed that they stay standing and all those other issues that come with that? And so that's why we have a desire where we think we want to go to keep us in there long term, but getting the architect engaged and then walking us through that process will help us get the best fix at the best value that we can come back and say, okay, here's the best value for us moving forward and getting this done correctly so we don't have this repeat, knock on wood, in 7 or 8 years.
So just to interpret your answer, to make sure I understand it correctly, you're saying really there's no way to even plan for the remediation funds until we get a more clear picture from the design firm. Am I understanding that correctly?
That is correct. To get it narrowed into something that we'd be comfortable going, hey, we think we can take it out. We can reprioritize some of these other facility repairs and do this first and then come back. This one that we really wanted to do, we'll just delay it until we have some ballpark. Like I used to tell people, give me ballpark, and they'd say, well, Chicago. Well, okay, that's kind of where we are. I mean, our owner's rep is saying, maybe $150 a square foot. But we don't know, again, what engineering and work has to go on to be able to do this in a long-term commercial type setting like it should have been done originally.
Understand. Thank you.
Mr. Mayor, I'd like to make
Edwards?
a motion that we approve resolution number 17R122.
Second.
I have a motion from Mr. Edwards, a second from Dr. Kaiser. Other questions from council? Mr. Crawford.
Question from what Mr. Larson was asking. So we have no idea what this may cost down the road, correct? And that's okay. I just
Yes, that's correct. We hesitate to even try to guess what it may be until.
And the other question, not that it matters at this point necessarily, but do we have any idea why they didn't use commercial grade materials in that rec center when they built it?
My best bet would be, like everything else on that project and Fire Station 2, that it was a cost savings measure at the time.
And my last question, I hope, do we need to specify in our motion that we're approving the $86,000 as a total contract amount to be paid to this company LPA for this year, but the amount we're approving to spend is only $68,000?
That's a procedural question, and the way I would answer that is if you would feel more comfortable amending the motion and making that statement, that's certainly within your purview to do as you have the floor.
Could we amend the motion to do that, please?
Mr. Mayor, I will withdraw my motion.
So we procedurally now we have we had a motion that was made. We had a second that was made. We had an amendment that was offered. The original motion was rescinded. Therefore, the amendment that was offered is moot. So at this point, we will start over and see if there's another motion that anyone on the council would like to make with regard to 17R122.
Point of order. Mr. Mayor, isn't that not addressed in the actual resolution itself? If you look at section
1 and 2.
1 and 2 of the actual resolution, section 1 says all projects not to exceed $86,000 for 2017-2018 fiscal year, and then section 3 says that for the YMCA design 47 with a contingency of 4756, not to exceed 52,316 for the Y.
I believe that is correct, but when Mr. Crawford had the floor, I did want to make sure that I offered and he understood that he could offer an amendment, just clarifying that as part of the motion. There's nothing wrong with clarification, particularly in the form of an amendment to existing motion. So that was the reason that I said it the way that I did. So at this point, we do not have a motion on the floor. Mr. Edwards, would you like to make a motion?
Mr. Mayor, I'd like to make a motion that we approve resolution number 17R122.
Second.
I have a motion from Mr. Edwards. I have a second from Dr. Kaiser. Any other comments, questions from the council? Appears to be none. I'll call for a vote. Mr. Edwards.
Oh, go ahead.
Aye.
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 7 ayes, no nays. The motion carries. Thank you, Mr. Waite. Next item we have on the agenda, because we took care of item number 8 on consent, is a roll call vote confirmation. Ms. Donna, we bounced all over the place and had all kinds of fun things. So why don't we walk through this, and if you need to, I'll jump in and help where I can. Our procedural machinations get more interesting every week.
So, I'm gonna have to go out and have a drink after this. Okay, like I said, I don't know how much of this I captured that's accurate. I'm gonna go with just the items rather than repeat the motions where we withdrew and all of that.
No problem.
Okay. For the consent items, it was 3, 5, and 8, and the motion was made by Councilmember Larson, seconded by Councilmember Davis. What you have?
So there was the Councilman Larson and Councilman Davis
Right.
were the ones that made the motion and second for the procedural matter of adding the amendment.
That was for the
was
procedure?
correct. I think that was the amendment, and then the original motion was made, if I'm correct, by Mr. Edwards.
And Crawford?
And seconded by Mr. Crawford.
Okay.
I have that correct as well.
Okay. And Mayor Pro Tem Edwards, Davis, Council Members Davis, Gutierrez, Larson, Scagliola, Kaiser, and Crawford all voted yes, so the motion passed.
Yes, so there were 7 ayes and no nays, both on the amendment and on the main motion.
Right.
Indeed.
Okay, then on item number 1, the minutes for December the 1st and December the 5th. The motion was made by Mayor Carpenter, seconded by Mayor Pro Tem Edwards. Mayor Pro Tem Edwards voted yes. Davis, Gutierrez, Larson, Scagliola, Kaiser, and Crawford voted yes. Motion passed. The December 12th minutes, it was decided to have the city secretary's office make a correction and bring those back on the voting.
So there were in fact, that was in fact the vote. So the vote was to approve, the motion was to approve December 1, 2017 minutes and regular meeting minutes of December 5th, 2017. I think I asked, is there a motion to approve those two? Is the recollection that I made that motion, or did I in fact? Okay, so that is correct then. I made the motion from the chair, and Mr. Davis seconded the motion. And it was a unanimous vote to approve the two and take no action on the minutes of December 12th.
Right, okay.
Perfect, thank you all.
All right. Okay, then item number 2, the garage sale signs. That would be ordinance 17L51. Motion was made by Councilmember Crawford, seconded by Councilmember Scagliola. The motion was to approve as it was written, and then ask staff to come back in April with a review and update on the results. And Mayor Pro Tem Edwards voted yes. Council members Davis, Gutierrez, Larson, Scagliola, Kaiser, and Crawford voted yes. Motion passed.
Precisely. Yes.
Okay. Item number 4, Resolution 17R121. Councilmember Davis made the motion, seconded by Councilmember Gutierrez. Mayor Pro Tem Edwards voted yes. Council members Davis, Gutierrez, Larson, Scagliola, Kaiser, and Crawford voted yes. Motion passed. Item number 6, Resolution 17R125. Councilmember Larson made the motion, seconded by Councilmember Crawford. Mayor Pro Tem Edwards voted yes. Council members Davis, Gutierrez, Larson, Scagliola, Kaiser, and Crawford voted yes. Motion passed. And item number 7, Resolution 17R122. Motion was made by Mayor Pro Tem Edwards, seconded by Councilmember Kaiser. Mayor Pro Tem Edwards voted yes. Council members Davis, Gutierrez, Larson, Scagliola, Kaiser, and Crawford voted yes. Motion passed.
To my recollection, you have it exactly.
Thank you.
Very good. Thank you. Next item that we have on the agenda, requested announcements, item number 9, announcements by the city manager. Anything further, Mr. Kessel, this evening?
I do, Mr. Mayor.
Very good.
Mayor, Council, I just want to wish each and every one of you a very Merry Christmas to you and your families. And by council, I also include our council, and staff, and the citizens. So, Merry Christmas.
Thank you, sir. Next item that we have on the agenda is item 10, request by the mayor and council members that items be placed on a future city council agenda. Do we have anything that we currently don't have scheduled that we need scheduled on a future agenda? Hearing that there's none, I'll just make the comment that in the last meeting, Dr. Scagliola asked that we have a discussion in the future with regard to the potential development of a social media guidelines or policy and thereabouts. So my plan was, and if anybody would like to help me adjust my thinking, grab me after the meeting to do that after we had an opportunity to hear from our city attorney this evening. However, Dr. Scagliola, you said this evening that you would like to see what's been put together for the city and for the city policy and training. So if there's no objection from council, I'm going to wait for Dr. Scagliola to inform me when those things that he has asked for have been met, and then we'll get that placed on the agenda if that's acceptable to everyone. Very good, sir. All right, we'll accommodate whatever you'd like to do on that. That said, we're item number 11, announcements by the mayor and council members, and I'll start with Mayor Pro Tem Edwards.
Mr. Mayor, I just want to wish everyone a Merry Christmas and a Happy New Year, since this is going to be our last meeting. And you guys be safe and be prosperous out there.
Thank you, sir. Mr. Davis?
Nothing, sir.
Mr. Gutierrez?
A couple of things. First of all, I want to thank Mr. Kessel for providing judges for the Senior Center Christmas party. It was a great success. They're still talking about it. Also special thanks to the city of Cibolo for Mayor Stosh being out there and two of the council members. And I just want to wish the city and the staff a Merry Christmas and a Happy New Year.
Thank you, sir. Mr. Larson? Dr. Scagliola?
Just, hey, Merry Christmas, Happy New Year. Like Councilmember Edwards said, be safe out there.
Very good. Dr. Kaiser?
Yeah, happy holidays to everybody, regardless of which one you may be celebrating this season.
Very good. Mr. Crawford?
Merry Christmas and Happy New Year's to everybody, council, in the audience, behind the glass window over there and back in the back room, and over here that I can't see ever. I hope y'all have a great holiday season. Thank you.
Thank you, Mr. Crawford. And to echo the comments of my colleagues, a Merry Christmas and a wonderful holiday season to all, and a very happy and prosperous new year for everyone. If there's nothing else from council or from staff, then we stand adjourned.
And just a reminder, we do have a Main Street Committee meeting.
As soon as I sort through what I'm supposed to sign and not sign, I'll be right there.